Dismiss from that set. Appeal hearing. Don't mention right now. Appeal hearing. We know, but we have not been able to dispose of so many matters. Yes. Applications. Order 41. Please hand over without mention. Let us complete this. Then we'll take
Order
up.
41 application.
Very urgent. Order 41 application. Don't mention. Hand over direct.
Order 41.
Your Lordship, one very urgent appeal.
We'll take up the other mentions. First, the order 41 applications. Let the crowd be dispersed.
Review
It's an application. Review is an application.
application.
Application and order 41. Please hand over first.
Lordship, may I permit?
Application order 41 over. No
Lordship,
further mentioning of
Lordship,
application.
may I permit it one, Lordship?
Yes, the other mentions.
My lord, we have mentioned a matter, my lord. Personally, lordship direction, medicine center, the matter is heard, but result is not fruitful. That's why I am mentioning after giving notice to the object.
This is the appeal. Appeal hearing. Please wait for some time. We understand your agony, but please wait for some time.
Short matter, my lord.
Many appeals are short.
Mediation, it is short.
We
That's
know.
why I am mentioning this.
We know, but there are other short matters also. Let us dispose of some appeals, then we'll take up. Probably the next month we'll be taking up appeal.
Next month.
Not before that, at least.
Wait,
Maybe
my lord.
even after that. Yes.
Yes. Lordship, I want to mention this matter.
What is
The respondents were
this for inclusion in the list?
for inclusion.
Application or what?
No, it's a motion matter.
No motion matters. There is no motion matter in our bench. Please ascertain first what it is.
Uh,
My lord,
Yes.
hearing matter, my lord, only mentioning hearing appeal, my lord.
You have done your duty. We are doing our
No, no.
duty. No.
My mother suffering cancer, my lord. This is land acquisition matter.
We are very sorry, but we cannot add now. Yes.
It's an appeal, Your Lordship.
Appeal don't.
My lord, under compelling circumstances, application for upgradation, my lord, item number 98 of my lord's list. My lord, the
It will appear under the hearing for dismissal.
kindly
Hand over the application.
grateful.
Yes. Tribunal motion. Tribunal
Lordship,
motion.
Lordship, the respondents were
It
directed
is
to.
also tribunal motion against the
Yes, it's a tribunal motion.
Yes.
My lord, next month.
Assign matter, my
It's an appeal.
lord. Review application.
Please hand over.
My lord, next month appeal would be had.
Next month, we are not sure. Let us try to dispose of as many first appeals as possible. You
As
cooperate
per-
with us.
as
We'll
per
dispose of
direction.
some appeals, then we'll start adding. Yes.
My lord, to be mentioned, my lord has passed the order 16.
Correction.
My lord,
Yes.
may be permitted to mention one matter for inclusion, my lord.
What is the matter? Under which hearing?
This is a appeal matter, my lord. This is
Appeal
pending.
hearing we are not adding right now. Yes, Mr. Krishna.
Mention a contempt application, a new
Applicants.
application.
If it's an appeal hearing, no, not right now.
This is a very short matter.
We understand. Many of the matters are short.
Time, man. This is the fourth time.
You can multiply the numbers of times of mentioning, but we cannot add them.
This is a senior citizen.
Call on the list.
That assigned matter, my lord. Your lordship and Justice Krishna Rao, my lord. Order passed by Justice Subudh.
Hand it over whenever we'll
File is coming.
রেখে দেয় এটা মনে করিয়ে দিও বলো কি কৃষ্ণা yeah call on the list.
I am for pro forma response.
Accordingly, MAT 989 of 2025, MAT 990 of 2020, and MAT 991 of 2025 are allowed on contest, thereby setting aside the impugned order dated June 19, 2025, passed in connection with can such and such, can 1 and can 2, arising out of WPA and in respect of CPAN. The learned single judge is requested to take up all pending applications together as per the convenience of the said bench by disposing of the recall application of the respondent number 5 to 7 and the clarificatory application filed by the Axis Bank first, and thereafter to decide on the contempt application subject to the outcome of the recall application. Consequentially, the connected stay applications bearing can 1 of 2025 filed in connection with all the aforesaid appeals stand disposed of. We hasten to add that this court has not decided on merits any of the issues involved in the applications pending before the writ court, and all the above observations are tentative in nature, only conclusive so far as the disposal of the present appeals and connected applications is concerned, and the findings and observations of this court shall not in any manner prejudice the rights and conditions of any of the parties in the pending applications before the learned single judge. No address to cause urgent side.
Great. Much obliged.
Well, in this matter, my lord, I'm praying for not today, for today and tomorrow, my lord. Not
Why?
today and tomorrow. My lord, Mr. Bhudev Chaudhary has some.
Extension of interim order.
This
But-
this
but
is
my
that
lord, there is
matter
hearing
in
also,
which,
my lord.
which an eviction decree was stayed without payment of occupational charges because
So
my
they are
lord,
not
if it-
pressing extension, then we are.
No, today, the extension is till 9th, my lord.
Right.
My lord, I'm praying for fix it day after tomorrow, my lord.
You want it day after tomorrow.
Yes, my lord.
That means on 7th.
7th, my lord.
Very well. On the prayer of the appellant, the matter is adjourned till January 7, 2026. Please come back on that. Mr. Mishra, your appearance only.
My lord,
Your appearance only, not Mr. Chat.
no, he is not today, has not come here.
Yes. This is item 5. 5 is appearing.
I mean, for the applicant, my lord, pursuant to lawsuit direction, we have tried to serve, my lord, but some of it has come back. So lordship kindly gives us some time to file out if you need a service. And if your lordship kindly takes up on any day subject to or
Then, Mr. Bade, why don't you go to the learned single? This is for restoration also.
for restoration.
Oh, achha, achha.
Well, I am appearing on respond number 4 and 13.
Yes, all have not
For
been served.
restoration is concerned, my lord, if my learned friend, subject to what my learned friend says and what my subject to.
But without substitution, you cannot do that, Mr.
Yes,
Bade. That is a
substitution.
difficulty. That is the difficulty. So when should you keep it? Let it go out of the list whenever you serve and come back.
We have already served, my lord. The only one has come back with.
We'll keep it next week then? Next week.
My
Very
lord,
well.
kindly.
On the prayer of the appellants, comma, in view of service having not been effected on all the respondents, comma, let the matter stand adjourned till January 13, 2026. Can seat নেই একটু দেখে নেবেন ক্যান সিটা নেই বলছি
এটা ক্যান্সি কপি দিয়ে দেবেন আপনার ফোন নম্বরটা রেখে দেবেন
দেখে নিতে হবে can 3 your application can 3
Yes.
second judge's copy is not there, Mr. Dey. Just supply that can 3 whenever you can during the course of the day, please supply. We'll put it on the file.
My lord, I shall
Next
certainly.
one.
Can 3 second judgeর কপি নেই ওইটা একটু দেখিয়ে নিতে হবে
Your Lordship, in item number 6, I appear for the appellant. Your Lordship, pursuant to the direction dated 17 December 2025, Your Lordship, we have served all the respondents. However, 3 respondents could not be served.
What was the endorsement?
Your Lordship, I'm due to the midst of time, affidavit of service has not been affirmed. I'm preparing it. It's returned with insufficient. One has returned with insufficient address, and other 2 has been addressee not found.
They contested in the trial court.
Your Lordship, yes. However, they are the legal heirs, Your Lordship. During the midst of this appeal, 3 of
These 2 applications.
Your Lordship, 1 application is for restoration, 1 application is for substitution.
So the persons who could not be served are the proposed
Substitution, yes, Your Lordship.
Then you can take up the application. No difficulty. You can file your affidavit of service during the course of
the day. Yes, Your Lordship.
Learned counsel for the appellants seeks leave to file the affidavit of service during the course of the day. Such leave is granted. Subject to such leave, comma, the applications are taken up for hearing. Next para, it transpires that apart from some of the proposed substituted respondents, comma, substantial service has been effected on the respondents. Accordingly, the applications are taken up for hearing ex parte, comma, since the respondents are not represented through counsel. So the restoration is within time.
Your Lordship, we came to know about the restoration that the appeal got dismissed on 25 March 2023, Your Lordship.
And when did you file it?
Your Lordship, we filed it on 10th April 2023, Your Lordship.
Then it's within time.
It's within time.
Yes. The substitution of whose heirs?
Substitution of Your Lordship of
Aropi Das.
4, 5, and Your Lordship 8.
All 3 have died?
Yes, Your
After
Lordship.
the filing of the appeal?
Yes, yes. Your Lord,
very well. Have you stated that they're major and sui juris and all these things? Yes, major and sui juris. Can 2 of 2023 is an application for substitution of the heirs and legal representatives of the original respondent numbers 4, 5, and 8.
8.
4, 5, and 8 who have died during pendency of the appeal. Push up next para. Upon a perusal of the application, comma, we find that the same is in form. Full stop. Accordingly, is there any delay in preferring the application?
Absolutely, no,
Accordingly, can 2 of 2023 is allowed, comma, thereby directing substitution of the heirs and legal representatives of the deceased respondent numbers 4, 5, and 8 in place and stead of the said deceased. Full stop. The department shall carry out the necessary rectifications in the memorandum of the appeal accordingly in terms of the above order. Full stop. No order is to cost. Full stop. Next para. Upon a perusal of Can 1 of 2023, we find sufficient explanation for the absence of the appellants on the relevant date. Full stop. Accordingly, Can 1 of 2023 is allowed, comma, thereby recalling the order dated February 21, 2019, whereby ACT 230 of 2018 was dismissed for default and restoring the said appeal to its original file and number. Full stop. Next para. The appeal be placed in the list under the heading Order 41 Rule 11 on January 13, 2026. It was not never admitted, obviously. Yes. So it will appear for admission hearing on
During the course of the case.
Item number 7, I'm appealing for the appellant hearing, my lord.
Yes.
Hearing is order 41 rule 19 application, but there is a delay of 2 days only, my lord. So I have to serve, my lord, probably.
No, did they appear at that point of time?
No, they didn't appear. No, they didn't appear, my lord. At the page 8, my lord. Oh, service is not required. Then my service is not required, my lord.
This is Can 1.
Yes, ma'am. At that point of time, my lord, this is Can 1 only, man.
Yes.
Because my application.
It was Can 508.
Yes.
The present application is one for restoration of the appeal upon recalling the order dismissing the same. Push up next para. Although there is a minuscule delay of 2 days in preferring the application, comma, since no right of hearing accrued in favor of the respondent at the stage of hearing under Order 41 Rule 11 of the Code of Civil Procedure, comma, at which stage the appeal was dismissed for default, comma, we dispense with prior service of notice of the application. Full stop. Next para. Upon perusal of the application, we find sufficient reason in the sufficient explanation for the delay occasioned in filing the application as well as the absence of the appellant on the relevant date. Full stop. Accordingly, Can 1 of 2020 within bracket old number Can 508 of 2020 is allowed, comma, thereby recalling the order dated December 6, 2019 and restoring ACT 486 of 2018 to its original file and number. Full stop. Let the appeal be listed for hearing under the heading Order 41 Rule 11 on January 13, 2020.
Yes, ma'am. Left for ma'am.
Thank you. Next.
Item number 8.
For the appellant petitioner.
Yes, Mr. Bhattacharya.
2, there was a direction for service. This is application for substitution after setting aside abatement. Pursuant to your lordship's direction, have served regarding service upon respondent number 8 and 10. They have come back, with the instruction, insufficient address. This was the address produced by them by their advocate.
They were plaintiffs in the trial. No, they were defendants.
No, I'm appearing on, I got instruction to appear yesterday on behalf of 1, 2, 3. Therefore, my lord.
1, 2, 3, Mr. Bhattacharya, 8 and 10 you said.
8
It
and
is
10.
still a legal errors. But I shall file the, kindly.
My learned friend, files the Vakalatnama, I have no problem. If your lordship would kind enough to come.
Your lordship will kindly take it.
No, let us just hear him. Yes.
Yes. Kindly comes to my lord, page 10 of Can 2.
Yes.
Kindly see, I write the letter to the advocate advocate. I'm saying that advocate on record, of the original respondent. Kindly see the date 12 May 2023. I say that this is to inform you that one reliable sources, the appellant has come to know from the fact about the fact.
This was for advocate for respondent number.
Only sole respondent. factum of the death of the sole respondent herein, who are there for
No, the proposed substituted respondents have not been served.
Yes, only 8 and 10.
Yes, Mr. What do you say to this?
Kindly-
Substitution application was
kindly take it next
Milord, 3rd May, Milord.
What is the delay?
Yes, kindly see page 11. Milord, their advocate, Milord, gives Milord intimation from 12th May 2023 to 3rd May 2024 after 1 year.
Yes,
And
Mr. They will.
Milord,
after that, we have filed this application. Milord, it is a delay of Milord 204 days.
204, including that period when you can, after knowing.
And 90 days, Milord, 204 days.
No, after coming to know, how soon you filed it?
Milord, immediately, it was affirmed on.
Yes, Mr. Das, we are allowed.
Milord,
20th May.
let the other responding.
No. And file your affidavit of service. Affidavit of service
Address was given by them.
Affidavit of service filed today be kept on record. Full stop. Despite attempt to serve, comma, only the respondent proposed substituted respondent numbers 8 and 10 could not be served, comma, despite the service being sought to be effected at the address given on behalf of the deceased respondent. Full stop. Next para, learned counsel for the appellant relies on the annexures to the application bearing Can 2 of 2024, comma, from which it transpires that despite the appellant's advocate having written to the erstwhile advocate of the deceased respondent on May 12, 2023, comma, the information regarding the date of demise of the deceased respondent was given on May 3, 2024. Full stop. Next para. Upon hearing learned counsel for the appellant and the respondent numbers 1 to 3, comma, who are represented by advocate, comma, we are of the opinion that sufficient explanation for the delay in making the application has been made out. Full stop. Accordingly, Can 2 of 2024 is allowed, comma, thereby directing substitution of the heirs and legal representatives of the sole respondent Kanailal Purkait, comma, since deceased, comma, after setting aside abatement and on condonation of delay in filing the application. Full stop. Next para. The said heirs, how many heirs?
Milord,
Several.
kindly see page
Yeah,
5.
the said heirs, comma, as mentioned in the cause title of the present application, comma, shall be shall be added as party respondents in place and stead of the said deceased. Full stop. The necessary consequential correction to the memorandum of the appeal shall be carried out by the department within a week from date. Full stop. Next para. The appeal be listed for hearing under the heading Order 41 Rule 11.
No, first appeal.
First appeal.
Oh, acha. Then
Paper direction for filing paper book.
Milord, there is another application, Milord, for injunction. Kindly see, Milord, the order dated 5th of May 2022, passed by the Honorable Division Bench.
For the injunction matter, then I will have to take in some.
Kindly, Milord, once see, Milord, the 5th of May, Milord, 2022.
You deposit the entire amount.
That is the thing, Milord. My client has, Milord, come to know substituted heirs had already created third-party interest. That's why my client is of the view, Milord, this would be redundant, Milord, in depositing this amount. If my learned friend says they have not created third-party
Let them
interest,
take instruction.
then I will deposit.
The matter will appear na kore. Can 1 of 2022 shall be listed for hearing under the appropriate heading on January 13, 2026. Please come back on that date with the instruction. Appropriate heading for the application. Nine, yes.
And 9 to 21, Mr. Sushovan Gupta. 9 to 21.
9 to 21.
I've been
Well,
requested
happy
by
New Year,
clerk
Your
to,
Honor.
Milord, to pay for a short Passover.
Yes, Mr. Mukherjee.
9 to 21 on the last occasion.
What is your prayer? You're appearing?
No, Mr. Sengupta's class requested me to pray for a short Passover.
Which Mr. Sengupta?
Sushovan Sengupta.
Yes, Mr. Mukherjee, whatever you say.
No, on the last occasion also they took it. Anyway, all not today.
An adjournment is sought on behalf of the appellant. Let the matter stand adjourned for the day.
Yes.
And my lord, Happy New Year.
Same to you. Thank you.
Item number 22.
22, I appear for the appellant, my lord.
Milord, I appear
My
for
lord,
the respondent.
though-
Milord, talks of settlement.
My lord, my lord, though mediation has failed, my lord, in this matter, but there is a settlement, talks of settlement is going on, my lord, and as far as the application is concerned, it is for the vacating of that, so kindly keep after.
Go out of the list for the present whenever talks of
No,
settlement.
after 2 weeks, you'll also keep the matter.
Let it go out of the list with my lord.
Council,
Can you please
Rohit,
fix the matter?
can you please fix the matter?
How much?
Learned counsel for both parties submit that despite attempts at mediation by the mediation through the Calcutta High Court Mediation Committee having failed, the parties are attempting to settle the matter between themselves. Full stop. Next para, accordingly, let the matter go out of the list.
Milord,
with
instead of out of
liberty,
list,
no, with liberty to
3
the
weeks.
parties to mention for inclusion in the list as and when the terms of settlement reach finality, comma, alternatively, if the attempts at settlement finally fail. Either way, you are.
Yes.
You are.
No,
Due to the logjam in the list, we cannot add matters. So we won't keep matters in the list unless.
Yes, my lord, I am for the appellant.
Yes.
Your lordship on the last occasion, my lord, directed us.
Directed you to do what, Mr. Mukherjee?
Will directed to serve copy upon all the
It
parties.
is a condonation application.
Yes, two condonation.
What is the delay?
Delay, my lord, practically was wrong advised. Delay, my lord, about what? About 559 days. Already judgment was passed.
What was the wrong advice?
Wrong, my lord, advice because my lord, by
The
the
first, Mr. Mukherjee, you have served on both the respondents.
all the respondents. My
And
lord,
the affidavit of
affidavit of service, my lord, all has return has not come back. We have gone for this.
You are appearing for respondent two only. Two and one appeared together in the trial.
Milord,
Both
one
appeared.
died. Milord, I am the sole administrator.
You are the only heir.
Milord. No. So many years are there, Milord.
Yes.
Will has been, Milord.
My lord,
One will has
all-
been prepared, Milord.
I am telling your lordship.
My lord,
What happened?
Milord, without wasting
Respondent number
my
one
time.
was expunged.
Yes, that is the mother. My lord, what happened? All these are sons and daughters. Total 9.
The other sons and daughters are parties.
Parties,
Informer.
yes. And the my lord, the person whose name was expunged was the mother.
Then you are the sole plaintiff now. Plaintiff is represented.
No,
So
Milord,
yes, what you have told.
Milord,
It has been
shares
filed
are
by
there.
them.
We are telling you. We are telling you this. This arises from partition suit.
No. The party, my lord, the
What is the suit for? What was
my lord, the suit for declaration injunction is filed by them for declaration of the share.
No, if you two were only the plaintiffs
Yes.
and one has died and the others are already on record,
Yes.
then you are the interested party because you
That's the
already.
interested party.
Yes, that's
Milord,
it.
So what do you say on this section 5 application?
Milord, I want Milord file opposition, Milord, because he is trying to delay the matter, Milord. Execution process, Milord, in process, Milord.
If you file opposition, then that will delay the matter.
Milord,
You should have been prepared with the opposition. You have been served long.
Short time, Milord, only 2 weeks, Milord. Give me, Milord.
My lord,
But we cannot execute in the meantime. We will grant execute.
Only 2 years, Milord. No, no execution, Milord. In the meantime, Milord.
Should you record your submission on that?
No, my lord, I tell you.
Milord, your lordship, Milord, no stay, Milord.
In the year on 15 years
2019 order has been passed.
kindly allow me.
Milord,
I am the
no,
appellant.
sorry.
Please. My lord, we actually on the their relinquishment, I being the youngest son, at that time when the share has got no value, I was directed and given by them relinquishment.
That is on the merits, Mr. Mukherjee.
I am coming to it. And my lord, that was succession certificate was granted long before 1983. In the year after 22 years, my lord, they filed a suit for declaration injunction, and that was, my lord, degreed. And in spite of that limitation, relinquishment, everything was taken point, evidence was given. Now, after that, my lawyer who was conducting the case never advised me anything. What happened or what?
Let them file an opposition, they are entitled to.
Thereafter, they have again filed a review application. This is not the execution process. Review application for modification of the order. That mixed case should be stayed. That is why, my lord.
No, first the section 5 has to be allowed.
Yes.
Learned counsel for the respondent number 2, comma, who was the co-plaintiff with the deceased respondent number 1, comma, seeks some time to file an opposition to the condonation application. Full stop. Accordingly, the respondent number 2 is directed to file affidavit in opposition to Can 2 of 2023 within a fortnight from date.
My lord.
The application shall be the reply, if any, shall be filed within a week thereafter. The application shall be listed next on January 28, 2026 under the heading application.
My lord.
Full stop.
This case, my lord, may be stayed because the hearing is going on.
Miss case
Or review.
yes,
that order.
you contest that within 2 weeks, nothing. 3 weeks, nothing.
All
Next,
right,
next.
And my lord, I am giving undertaking to file affidavit of service in course of this day. It has gone for
আচ্ছা প্রথমেই করে দিন তাহলে on the prayer of learned counsel appearing for the appellant, comma, leave is granted to the appellants to file affidavit of service during the course of the day. Next.
বলে দিয়ে যাবে ওটা দিয়ে দিয়েছিস I'm grateful.
Thank you.
Beg to appear for the applicant.
Yes, yes. What is the matter?
This is the my Can 2 application is my application for reimposition of the stay order, which was subsequently vacated due to failure on the part of the applicant to pay the occupational charges.
Now what?
Now, my lord, what I have
You have paid the occupation charges now?
I was paying. There was a direction, first direction to pay 1 lakh that was deposited. Thereafter, till December 2024, I paid 10,000. From October 2023 to December 2024, I have paid 10,000 per month. Thereafter, I have, my lord.
What was the exact direction? What was the modality of payment?
That is page 8, my lord, in Can 2 application.
Party. Acha, very well. 1 lakh by installments, 10,000 per month.
Thereafter, after paying 1 lakh, thereafter, month by month, 10,000.
Acha.
Till, my lord, December 2024, 10,000 was paid by the appellant.
Then what happened?
Thereafter, my lord, there was some, I have filed one supplementary affidavit, my lord.
What do you say? What is your reason?
In my paragraph 5, I have stated my father, one Ashok Das,
Yes.
was admitted for more than 1 month in hospital.
Right.
And the petitioner has paid, my lord, in the next paragraph, I have stated 1,57,000 to that effect for the treatment of our
So
father.
you could not pay it from January 2025 onwards.
January 2025, but I have tried to pay. I tried, my lord, and in March 2025, I have paid 10,000.
But what about January and February?
I did not.
We are allowing this application reimposing, but you have to put in the entire arrears within 1 week. You should be ready when you file the application. That's your prayer.
Yes,
that
my
you
lord.
put
That I will pay. But if my lord kindly
arrears at a time, that is your prayer.
that I will pay. But kindly, if my lord gives me
Arrears
2
you
weeks
have to
time,
pay within 1 week.
I will. But kindly
1
give
week,
me 2 weeks.
1 week. You should be ready with the money when you file this application.
My lord.
This is no further time. Can 2 of none appears for the respondent. You have served on the respondent.
My lord.
Despite service, none appears for the respondents at the time of call. Full stop. Next para. We find from the order sheet that on the last occasion when the matter was called on for hearing, that is on December 24, 2025, the matter had been adjourned at the behest of the respondents. Full stop. Next para. Accordingly, we take up the matter for hearing ex parte. Full stop. Initially, by an order dated October 18, 2023, passed in connection with Can 1 of 2023, made in the present appeal, an order of stay of execution of this is an eviction decree.
My lord.
Of the eviction decree from which the appeal arises was passed, on condition that the appellant shall deposit a sum of rupees 1 lakh within 7 days from that date, and thereafter rupees 10,000 each month as occupation charges. Full stop. Despite the occupation charges having been paid up to the month of December 2024, in view of the ailment and hospitalization of the father of the appellant, who is of advanced years, huge expenses had to be borne by the appellant, due to which the occupation charges could not be paid for the months of January and February 2025. Full stop. However, it is submitted that occupation charges for March 2025 has been paid. Full stop. Next para, by the present application, the appellant seeks liberty to put in the entire arrears and thereafter to continue payment as per the previous order, subject to which reimposition of the stay order, which automatically stood vacated due to non-payment of occupation charges, is sought. Full stop. Next para. Upon hearing learned counsel for the appellant, we are satisfied that sufficient reason for the non-payment of some of the installments has been made out. Full stop. Accordingly, Can 2 of 2025 is allowed, thereby reimposing the stay of execution of the decree impugned in the appeal in terms of the order dated October 18, 2023, subject, however, to the appellant depositing the entire arrears of occupation charges till the month of December 2026. 2025 within, we will give it 2 weeks, within January 19, 2026. Full stop. Next para. Thereafter, sorry, ওটা করে দিন till January 2026, December 2025, till January 2026, by January 19, 2026. Full stop. Thereafter, the monthly occupation charges shall be paid at the rate of rupees 10,000 per month within the 5th day of each current English calendar month, starting from February 2026. Full stop. Next para. In default of any of the above payments, the interim order shall stand automatically vacated. Grateful. Thank you. No address to cause, Sergeant Secretary.
Item number 25.
By an order dated December 17, 2025, we had directed fresh service of the applications to be effected on the respondent. Full stop. Next para. An affidavit of service was also to be filed by the appellant on the returnable date. Full stop. However, today at the time of call, none appears for the parties. Full stop. Accordingly, let the application go out of the list with liberty to mention for inclusion as and when service is effected on the respondent. Out of the list.
Item number 26 with 27.
Your Lordship, I missed the brief. It is on its way. I am humbly praying for an adjournment for half an hour only, Your Lordship. Half an hour, Your Lordship.
We are
Pass over for
adjourning
half
for
an
the day. On the prayer of the appellant, let the matter stand adjourned for the appellants. Let the matter stand adjourned for the day. Next.
Item number 28.
None appears at the time of call for either of the parties. Full stop. From the order dated December 17, 2025, yes.
28.
Yes, move the matter.
Yeah.
What are it?
So, copy.
What are these?
Affidavit in service,
Affidavit of service.
in opposition. Apologies. And also the next.
You have to file your affidavit of assets also.
Yes, it is. It should be with it.
You have annexed it to the affidavit.
Yes, yes, Your Lordship.
All right. Yes.
Yeah.
What is this application for modification?
Application, Your Lordship. So this was basically, the last order was passed on 6th of August 2025, based on which we have filed for this modification application.
What was the amount directed?
It was initially till February 2024, it was 15,000 per month. That was supposed to be given to the wife. The current situation is, Your Lordship, the husband is a retired, like officer, ex-employee. So his monthly
When
pension.
did he retire? When was the order passed? First order?
First order was 6th August 2025.
6th August
2025, 6/8.
25.
Yes.
When did you retire?
Not very sure with the date, Your Lordship.
Then why should we modify it?
Because currently, his pension, the amount that he's
If you
receiving
don't
is
know whether he had already retired on the previous date, then how do you decide that? You can't even say when you retired. If he had already retired on 6th of August, then that was taken into consideration. What is the change of circumstance?
Your Lordship,
You don't even have basic preparation, ma'am.
I've
You
been
don't even have
instructed,
basic preparation.
senior, I've been instructed. So
Whatever senior, we will dismiss the application and we will direct you to pay alimony immediately. Otherwise, your client will go to jail. You have been evading alimony for quite some time.
till February 2024.
What is your pension? What is the
26,000, Your Lordship.
26,000?
2024 February, per month 15,000 amount was given.
When did you demit service?
Till February 2024.
Yes.
February 2024.
Where do we get it in your?
It is in page 4, Your Lordship.
Where do you say that you have retired on that date? What is the date of retirement? You have only stated that you duly complied till February 24.
Yes, Your Lordship.
You have never stated that you have retired or you have demitted office. Not even a single statement. When did you demit office? That is the only sentence which is relevant. When you retired. Only thing which is relevant. Nothing else is relevant. You are presently receiving monthly pension of rupees 26,000. Well and good, but initially 15,000 was directed.
Yes, Your Lordship. Till February 2000.
Why do you say in paragraph 11I that you have no obligation to pay 40,000 per month?
That is because
That is their claim.
currently, Your Lordship, the amount that he's receiving as pension is 26,000. So
Why do you say we cannot pay 40,000? Who asked you to pay 40,000? You are directed to pay 15,000. That's their prayer. So you earned 26,000 since when? When did you retire? You have not even stated that. Have you annexed anything to show that you have retired? And what is your pension?
yes, Your Lordship.
Show us.
Page 11.
Retired person, well and good. When did you retire? Where are the papers? This is your statement. Where are the supporting papers? How do we know you are getting pension of 26? There's not a single document annexed to show that your pension is 26, your bank statement or anything else. Nothing. And not only that, you have not even stated the date of your retirement anywhere throughout your application. Yes, what do you say?
But Mr. Munishankar Chakravarti is appearing on behalf
No,
of
no, no, we are not adjourning the matter.
But
No
due to
adjournment.
personal difficulty, he has not come.
No, no adjournment. You move the matter, sir.
But I'm not his matter. But one day,
They'll dispose of the application.
but give one day, if you lordship.
Yes, you have not disclosed your date of retirement.
You can,
Affidavit in opposition filed by the appellant husband, comma, annexing therewith the affidavit of assets of the husband, comma, filed today be kept on record, full stop, next para. Interestingly, comma, although the husband claims that he has paid alimony till February 2024 at the rate of rupees 15,000 per month, comma, it is nowhere stated within the four corners of the application or the affidavit of asset, comma, nor can learned counsel for the appellant apprise us as to the exact date of retirement of the appellant. Full stop, next para. Moreover, comma, we find from the affidavit of assets and the affidavit in opposition that not a single scrap of paper has been annexed thereto to indicate the exact date of retirement of the appellant husband and stroke or the actual amount obtained by the husband per month after demitting his office. Full stop. Accordingly, the appellant is directed to file a further short affidavit disclosing the relevant pleadings and supporting documents as to the exact date when the appellant demitted office and documents indicating as to the exact amount of pension drawn monthly by him as well as the amount disbursed in favor of the appellant husband in a lump sum manner, comma, if any, comma, at the time of retirement. So you will disclose the man, listen to us, listen to him later. You will disclose the date of retirement, supporting paper, exactly, it will be on your order, see the website, don't have to write it down. Date of retirement, supporting paper, one. Second, what lump sum you obtained at the time of retirement, supporting paper. What is the pension, monthly pension, supporting paper. Okay. We have put it in our order, please check the website. We are giving you 1 week's time. Within a week from date, bolechi. Comma, with an advance copy to the learned advocate for the respondent wife, full stop. The time for filing affidavit in reply to the affidavit in opposition as well as such supplementary affidavit is extended till a week thereafter. Full stop. Next para. The application shall next be listed for hearing on January 27, 2026. Do it within a week, please, and give a copy to him. You file, ask Mr. Chakravarti to file composite reply or separate replies to this as well as that within a week thereafter.
Good.
Thank you. Next.
I was
Copy service, Mr. Datta.
I was hoping that my other side would appear, and the service was affected, but it is misfortune that these
lost
is lost. And may I seek the liberty to serve again? And,
who is appearing for the respondent?
No one appeared.
For the first time last.
Oh, so this is the first time it appeared. We were directed to serve.
Learned counsel for the appellants candidly submits that despite services having been affected, comma, the relevant documents in support of such statement have been misplaced from the office of the learned advocate. Full stop. Be that as it may, comma, on the prayer of the appellants, comma, a fresh service of the applications is directed to be affected on the respondents. Full stop. An affidavit of service to that effect shall be filed on the returnable date. Full stop. Let the matter be listed in the monthly list of February 2026. Next.
My apologies.
No.
In this matter, Mr. Sudhir Kumar Das appeared with the appellant. He has lost his mother.
You're there, Mr. Kun. You move the application.
No, he has lost. I was supposed to file reply to the opposition. He is the advocate record. He has lost his mother the other day. Therefore, I'm praying only.
We'll keep it next monthly list then. Learned counsel for the appellant submits that due to a bereavement in the family of the learned advocate conducting the matter for the appellant, comma, the affidavit in reply could not be affirmed as per previous direction. Full stop. Accordingly, the time for filing reply is extended till February 2/2026, full stop. The matter shall be listed next in the monthly list of February 2026. হয়ে গেছে এই শুধু কি কুন্ডুর নাম আছে yes
appearing for the respondents number 1 and 2, Millet.
Respondents আছে
Millet.
on the last occasion also you had appeared.
No.
The respondents are represented to council, full stop. By an order dated December 17, 2025, comma, it was recorded that none had appeared to move the applications at the time of call. Full stop. We had further recorded that on November 25, 2025, comma, as well, comma, an adjournment was sought on behalf of the appellant. Full stop. Accordingly, comma, a last chance was given to the appellant to appear and move the applications. Full stop. Next para. However, comma, even today none appears to move the applications on behalf of the appellant. Full stop. Accordingly, both the cans are pending 1 and 2.
My lord.
Accordingly, can 1 of 2024 and can 2 of 2024 are dismissed for default without any order as to costs. Urgent certificate purpose. Please give your names. Yes.
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 My lord, kindly grant a passover, please.
No passover. You had been directed to correct the caption of the memorandum of appeal. Let us see. Directed to go out of the list then if you have not done it. Who is your senior, ma'am?
Ashish Bhattacharya.
Where is he? Why has he sent you?
He is in the 28, sir. My lord.
No, memorandum to correct. Very well. On the prayer of the appellant, the matter is adjourned for the day. Next. You give your name, please. Only your name. Give it right now. No, জানে না নতুন. Write it on a slip of paper. Write your name on a slip of paper. Yes.
I'm for the appellant.
Yes.
So this is an
I am for the respondent.
alimony pendenti light, my lord. Not the landed an offer has come from my other side counterpart that they want to go for a settlement, my lord.
That is to delay the matter.
No, my lord.
They want
Yes, yes.
No.
He's appearing.
My lord, yes.
Mr. Raj, that is only to delay them.
No, my lord.
Don't go for that offer. Move the appeal. You are for the wife.
I'm for the wife, my lord.
Yes, we direct the advocate appearing for the husband to pay. Yes. Why talks of settlement now when the matter is called on for hearing?
My lord,
What, my lord?
settlement can be arrived at any moment, my lord.
Yes, but why didn't you think of it earlier?
My lord, because
When did you give the offer first? When did you give the offer? Today?
2 days back.
2 days back.
Father,
When should you keep it?
1 week, not I'll in the meantime if we can arrive at some.
my lord, let it be 2 weeks, my lord. 2 weeks, my lord.
2 weeks corona.
Why? You'll collect the money in the meantime. The alimony.
My lord,
What, 2 weeks or 1? Whatever he says.
my lord, then 10 days, my lord. 10, 2 weeks.
We are very bad at bargaining. Then it becomes 3 days. On the prayer of learned counsel for the parties, comma, in view of talks of settlement apparently going on between the parties, comma, let the matter stand adjourned till January 19, 2026. 2 weeks. Yes.
No, I'm for the.
Yes, Mr. Bhattacharya.
My lord, affidavit has been extended in view of the lordship's orders, my lord. So far, the my lord condonation of delay is concerned.
Exchange and filed in court, or you are
Yes,
filing now?
yes. Last occasion, my lord, both my lord
File in court.
File in court.
Filed in court. Let us just
The last day we have filed.
just let us get hold of the opposition we have got. Yes, the reply also must be there. Yes.
Now, there is
Yes, you have got it.
There has been a delay of 432 days to preparing this appeal, my lord. Now, this is suit for ejectment of license, my lord, by the defendants. My
What is the
lord.
ground for such a long delay, Mr. Bhattacharya?
My lord, delay, my lord, what has happened, my lord? First of all, they received the notice and they, my lord, appeared. It is admitted position of fact they appeared.
You had appeared in the suit.
But first time they appeared. But thereafter, they didn't file in WS, my lord.
Lastly, ex parte degree.
Lastly, ex parte degree, my lord. my lord, due to my lord, the miscommunication between the parties and the advocates, my lord, this thing has been happened. My lord.
You
My lord,
appeared in the suit, you
my lord,
should have taken.
my lord, why this has been happening? My lord, they are also unable to say.
No, this
My
is
lord,
not a good job.
thereafter COVID situation come, they did not.
When was the degree passed?
The degree passed 2024, my lord, 31st of January 2024.
So how does the COVID help you?
My lord, when the suit was filed, my lord, they appeared. Thereafter, when COVID started, COVID started, my lord, the date was not informed by the advocate to the my lord.
Despite your client's prayers, COVID did not last for so long.
My lord,
So,
that is the reason.
2024, there was no COVID, January 2024.
The illiterate person, my lord, I have
We have exhausted our this feelings for illiterate persons.
I have taken
that quota is now over.
My lord, this is the fact, my lord.
Marginalized sections and illiterate persons, that quota is over.
This is the fact, my lord.
We are taking up this determination for
after getting the notice of
months,
execution,
illiterate person could contest the suit.
Well, that is no way, my lord. But the thing is this, my lord, the advocate has not informed that.
If I am illiterate, Mr. Bhattacharya, I'll be all the more careful to know from my advocate what is the fate of my suit. If I am literate, then I may be a bit more complacent.
But the advocate has not informed the date and whereabouts the.
Give a notice on the advocate.
That is the problem, to suffer.
Give a notice on the advocate, whom we are casting blame on that advocate. So give a notice to him later. Has been from him.
They just suppressed everything. My ground in opposition is that they have not mentioned anything. We in the opposition mentioned that you appeared.
You are not an illiterate person. You have signed. Illiterate means cannot sign. Sorry. Nothing.
But if your lordship kindly take.
What is your explanation? Let us see which paragraph explains it. Not as a matter of right. Those days are gone, Mr. Bhattacharya.
That's 2 and 4.
2 and 4. This is the entire explanation.
The appearance of the applicant came to know about the said order dated 31st of January 2024 only in the month of March 2025, when the notice of execution case was filed by the respondent herein, being the title execution case number such and such, and was served upon the applicant herein. The next date is fixed for such and the next paragraph, the applicant herein. There has been a delay of 430 days.
Disclose, my lord, in paragraph 4 that appeared and paid for time to file WS, then disappear.
No, we are dismissing this. Against eviction.
Eviction, my lord, it is admittedly it is property, my lord.
We cannot look into the grounds nowadays.
My lord, if your lordship kindly takes the ex parte order once, my lord.
Cannot.
My lord, kindly,
how the order has been,
how the order has been passed, kindly see.
No.
Only 2-line order, my lord.
It would have come up earlier. The present application is one for condonation of the delay of about
my application. That's the problem.
432 days in preferring the appeal. Push up, the appeal has been preferred against an eviction decree. Push up, next para, learned counsel for the appellant submits that the appellant is an illiterate person and is not aware of the nuances of law, and as such, only upon being informed of the execution case, took steps for preferring the present appeal. Push up, next para, learned counsel appearing for the decree holders stroke respondents submits that no explanation whatsoever has been given in the application for condonation of delay for the prolonged delay in preferring the appeal. Next para. Secondly, it is argued that the appellant has suppressed in the condonation application that the appellant had entered appearance in the suit and thereafter did not contest the same. Thus, it is submitted that the appellant all along had knowledge of the pendency of the suit. Next para. On a perusal of the application, we find that it has been suppressed that the appellant had appeared in the suit, and as such, it was within the know of the appellant about that the suit was pending. Despite the same we do not find any iota of pleading as to how the appellant was diligent in pursuing the suit. Next para. Even apart from the suppression of such material fact of the appellant having entered appearance in the suit and having knowledge of the same, we find precious nothing in the application by way of explanation for the delay in preferring the same. Also, we see from the affidavit supporting the application for condonation of delay that the appellant has signed the same and comma as such comma cannot be said to be illiterate as such. Full stop. Next para, be that as it may comma, since no explanation whatsoever has been given for the prolonged delay in preferring the appeal comma, we are unable to condone the delay in filing the appeal. Accordingly, can 1 of 2025 is dismissed on contest without any orders to cost. Full stop. Consequentially, FAT 172 of 2025 is dismissed as time barred. Full stop. As a necessary consequence, comma, can 2 of 2025 is also dismissed without any costs. Urgency report. প্রথমেই affidavit charge filed to be kept. Next. Yes.
I'm for the respondent, my lord.
Appellant Shobhan Mukherjee.
Matter was taken up on Lord 24th of December, my lord, when the interim order was reimposed by your lordship. They did not appear. Your lordship not vacated the interim order. They filed the application for reimposition. On 24th December, it was not reimposed. Application is pending. Now today, again, they are not appearing. Are we opposing the prayer for interim order, my lord?
Initially, there was an interim order which was reimposed.
Interim order, then we filed the opposition. Then, my lord, they did not appear and your lordship is vacated because of their non-appearance. Then they filed the application, got it reimposed.
We'll give them a last chance. We'll record that in order. None appears for the appellant at the time of call. Full stop. Learned counsel for the respondents points out that previously, due to non-appearance of the appellant, comma, the ad interim order granted in connection with the appeal had been vacated, comma, upon which a reimposition of the same was sought. Full stop. The stay was reimposed. Full stop. However, comma, again, comma, when the matter is called on for hearing today, comma, the appellant is conspicuous by his absence. Full stop. Next para. It appears that the appellant has adopted procrastinating tactics by conveniently being absent when the application is due to be heard and thereafter seeking reimposition of the interim order when the same is vacated. Full stop. We were initially bent upon to vacate the interim order again. Full stop. However, comma, since a plea has been taken out in the application that the appellant belongs to the marginalized sections of society, comma, we hereby give a last chance for the appellant to move the application. Full stop. Next para. It is, comma, however, comma, made clear that in the event the appellant remains unrepresented on the next occasion when the matter is called up for hearing, comma, we shall not show any further lenience and the matter may be, and ex parte orders may be passed in the absence of the appellant. Full stop. In the light of the above observations, comma, the applications are adjourned for the day. Thank you. Mr. Banerjee, please inform Mr. Shobhan Mukherjee is appearing, if you can, that we have passed such a stringent order, and if it does not appear, we'll dismiss. Again, vacate it maybe, or dismiss the application. Yes.
Please, Your Lordship, my lord, I'm appearing on behalf of the plaintiff, defendant, respondent.
None appears for the appellants at the time of call. Full stop. Next para. By an order dated December 24, 2025, comma, we had recorded that since allegations have been leveled in the condonation application against the erstwhile advocate within bracket S of the appellants, comma, a notice as well as a copy of the condonation application shall be served on the said erstwhile advocate within bracket S, comma, intimating that the applications shall be listed for hearing in the monthly list of January 2026. Full stop. The appellants were also directed to file an affidavit of service. Full stop. Next para. However, comma, today at the time of call, none appears for the appellants, comma, nor is any material placed before us to indicate that any notice has been served on the erstwhile advocate within bracket S of the appellants. Full stop. Accordingly, a last chance is given to the appellants to move the application. Full stop. In the event the appellants remain unrepresented on the next occasion when it is called on for hearing, comma, ex parte orders may be passed in the absence of the appellants. Full stop. The matter is adjourned for the day. Please inform Mr. Shobbosati Chatterjee or whoever is appearing with him that will dismiss it on the next session.
Obliged.
Next.
Madam, for the appellants, my lord, challenging the order which this court dismissed the appeal, my lord. They have filed an SLP before the Supreme Court. Although, my lord,
What is this application for?
this is an application for implementation of the order. But
What was the nature of the order?
But we have to file the affidavit of compliance, my lord, whereby the court ordered us to give us the we have to agree with the tenants that in certain time we will give back the.
You are the appellants here.
My lord, I'm the appellant.
You are landlords.
My lord.
So what was the nature of the? Can you tell us what is the nature of the impute? You cannot tell us anything.
The order was the appeal was dismissed on the ground that both the parties have reached a settlement, whereby, my lord, we had to file an affidavit of compliance, which we had to submit all the tenants are in agreement with us that in certain amount of time we will make the construction, complete the construction, and shift them back. And my lord, that order has been challenged, my lord, before the Honorable Supreme Court.
So implementation does.
Although, my lord, the SLP is showing as defective, but my only prayer will be that this application can be kept in the monthly list of February, and an outer limit be given to the respondents to cure the defects that is shown in the SLP, so that, my lord,
What is the time given to them?
No, I'm praying, my lord, that
we cannot give an outer limit for correcting the SLP that the Supreme Court can give.
But then let the matter be kept in the monthly list of February. The application we heard, if that, hopefully they'll clear.
The counsel for the appellant submits in his usual fairness that special petition has been filed against the judgment disposing of the appeal, the implementation of which has been sought by the present application. It is further submitted that the SLP is being shown in the official website of the Supreme Court as defective. Next para. We find from the order dated December 17, 2025 that the matter had been adjourned on a similar plea on the said occasion as well. Accordingly, let the matter be listed in the monthly list of February 2026. It is made clear that in the event the respondents take no steps in the meantime to move the SLP, appropriate orders may be passed the next occasion. On the next occasion.
Grateful.
February month list.
Your Lordship, I appear for the plaintiff appellant. Your Lordship, I have served the respondent number 1, 2, and 3 in an alternate address provided by them. However, Your Lordship, it is still, until this time, it is kept in deposit and has not been delivered yet.
When did you send?
The day this court reopened, on the 2nd of January. It was ordered.
Send it earlier. Learned counsel for the appellant submits that pursuant to a previous direction of this court, fresh service has been effected only on January 2, 2026 on the respondents at their alternative address. Next para. Learned counsel for the appellant seeks some time for the service to be effected. Accordingly, let the matter stand adjourned till the monthly list of February.
Your Lordship, for the other respondents, no alternate address has been found yet. Your Lordship has, in Your Lordship last direction, Your Lordship.
You have to find the alternative addresses. What can be done?
They had appeared in the same address.
On the next occasion, when we take up the matter, just remind us that the others have been, they appeared or whatever.
Grateful.
Make that submission on the next occasion.
Grateful.
February monthly list. Yes, next.
I am the applicant.
1 second. What application to tell us? 98. Yes.
Already respondent number 8 already died, my lord. Signed the application.
You would be happy if the others also died. Why is it so sad? Respondent 8 has died. This goes out of the list.
Yes,
you are for the appellants.
Yeah,
you are very happy. Learned counsel for the appellant submits that the respondent number 8 has died in the meantime and appropriate steps shall be taken by the appellants for substitution in that regard. Accordingly, let the matter go out of the list with liberty to the appellants to mention the matter as and when such substitution application is filed. Go out of the list. Next. Give your name, please. Yes. Next.
Item number 40.
Yes.
You're for the respondents.
I am from the petitioner.
1, 2, and 3.
What is the matter about?
Well, this is an appeal against.
No, they have to move their application. Yes.
Actually, PR is due to sickness. kindly adjourn to.
Out of the list.
Kindly, one thing I should.
They are enjoying an interim order.
There is an interim order.
We'll vacate that and put it out of the list.
Because on the basis of a wrong submission, by misleading this court, the documents which have been placed, an amended application was filed, wherein there's a categoric assertion by the petitioner that they had appeared in the revocation case.
What is this application? Appeal against, and what is the can?
An order of succession certificate was granted, against which an application for revocation was made.
And can 1 is?
Can 1 is an application for stay of the succession that was granted in favor of the respondents.
Right. What is the wrong misstatement made by them?
Well, there's a categoric assertion in paragraph 6, your lordship will find.
No, the application is with us.
This has not been annexed.
Paragraph
Paragraph 6, your lordship.
Yes, please. What is stated?
In paragraph 6, it has been categorically stated that they had appeared in the success when the application was moved for grant of succession certificate. They had appeared in that particular application.
So what do they say in paragraph 6?
My lord, let me.
Obtained the succession. They do not say that they did not appear.
They have said before your lordship that they did not appear when succession certificate was granted.
Is
And
it
on that basis,
is it recorded in your order?
My lord.
Let us see that order. 18th November.
My lord. Where's that order? Paragraph 5 at page 2, your lord.
Yes. No, we said that granted without citation upon the first wife. They're the first wife.
This is first. She claims to be the
first wife. There was citation and they appeared.
And my lord, in paragraph 6, they have mentioned in the amended plaint, your lordship will find that after paragraph 6.
Yes.
Your lordship will find in 1, 2, 3, 4, 5th line of paragraph 6.
Yes.
That it is pertinent to mention herein that in succession case number 5 of 2014, the petitioner appeared to the learned advocate Vishwabroto Roy and subsequently won settlement. So it is a false statement which has been made by the court, by the learned advocate appearing for the appellant, and this amended plaint, that the application has not been annexed in the CAN application. They have suppressed this particular application.
We'll vacate this stay. We'll grant you time, but we'll vacate this stay for suppression. At the time of call, are you ready with the matter?
Yes.
Move the matter. Why did you suppress this?
Kindly allow 1 minute, please.
Are you ready in the matter or not?
Immediately not.
Very well. We'll record that in our order that you are not immediately ready.
No, sir.
Yes, we will. Because we are vacating your order for suppression. What is your explanation for suppressing this? Can you give a copy to them?
My lord.
Maybe the counsel was not briefed properly by his
I've handled
client.
Paragraph 6.
An adjournment is sought by the appellant. Push up next para. Learned counsel for the respondent submits that an ad interim order was obtained by the appellant on November 18, 2025 from this court by misleading the court and suppressing the material fact that the appellant had appeared in the succession case, the revocation of which was refused by the order impugned in the appeal. Push up next para. We find from paragraph 5 of our order dated November 18, 2025, that one of the grounds on which interim order was granted was that the succession certificate was obtained without citation upon the first wife, within bracket, the present appellant, who claims to be the first wife of the deceased testator, bracket closed. Whereas from paragraph number 6 of the copy of the revocation case, as amended, which is handed over today in court by learned counsel for the respondent and kept on record, it is categorically found that the appellant had appeared in the succession case. First of next para, thus, such suppression of material fact and attempt to mislead the court would otherwise entitle the respondent to a vacating of the interim order granted by us on November 18, 2025. Full stop. However, comma, since it might not be the fault of the learned counsel for the appellant that material facts were suppressed from him by his client, comma, giving the benefit of doubt to the learned advocate for the appellant, comma, we request a copy of the amended plaint of the revocation case to be handed over to the learned advocate for the appellant, comma, which is done here and now by learned advocate for the respondent. Full stop. The learned advocate for the appellant shall apprise himself as to the real state of affairs. Full stop. For such purpose, comma, the matter is the application is adjourned till January 7, 2026, when it will be next taken up for hearing.
Oblige you. এটা থাকবে রেকর্ডে। My lord, the application amended plaint application should be kept on record.
We have stated that in the sentence itself. We have incorporated.
Oblige you, lordships.
Item number 41.
Well, I am on behalf of appellant, my lord. This is the supplementary memo of appeal.
Supplementary memo of appeal?
Yes, lordship, you are my lord
No,
directed.
supplementary affidavit.
Supplementary affidavit, supplement, my lord.
Mr. Ali, did you direct affidavits to be exchanged in the main
Yes,
application?
my lord. 1st December. Well, I have already given.
Lordship is directed for filing of supplementary affidavit.
Only.
Only.
Not.
No, I also supply to respondent.
Yes, I have received it.
So you had
There was
taken
no
a point that there was not a scrap of paper to show
that
they were not given opportunity for cross-examination. So what have you annexed here?
Lordship, my lord, kindly page 12 of the supplementary.
This arises from an eviction decree.
Yes, lordship.
Eviction
No,
decree.
No, recovery of poison, lordship.
No. This is a
It
probate
arises
proceeding.
from will
This is a probate proceeding. This is a probate
probate suit. Lordship, during the stage of argument, my lord.
It was granted.
Probate was granted.
Probate was granted, lordship. During the stage of argument, my lord, the issue of this case is not framed. And on the prayer of the petitioner respondent, the learned court framed the issue, and subsequently the appellant respondent filed a petition for recall of petitioner witness, PW1,
So
PW2.
you are given opportunity to cross-examine, but
No,
you sought for-
my lord, not given, my lord, not given, my lord.
But your application in the trial court, which you have annexed to the supplementary, says prayer for recall of PW1 such and such and PW2 for further
After recalling, my lord,
Let us complete one sentence.
Okay, my
Then we will complete one sentence. Then we will again complete one sentence, and we will
My
go on
lord.
this way. Please, yes. So from your application annexed to this,
my lord.
it appears that it is an application with a prayer for recall of PW1 and PW2 for further cross-examination, which means there was previously cross-examination. What is your answer to this?
Lordship, after that, the
You cannot start with after that. You are asking before
Lordship,
that.
respondent petitioner then filed a petition for adopting the exhaustion chief previously recorded, my lord. After subsequently, I filed the petition for after allowing the respondent petitioner to adopt his exhaustion chief, my lord. Then I filed a petition to cross-examine. It is my statutory right. After adopting the exhaustion chief by the petitioner, respondent petitioner, I have a statutory right to cross-examine, my lord. The learned trial court equate the recalling of petition and the prayer for cross-examining the petitioner, my lord. This is the main.
In the probate case, you are defendant number which defendant?
The only one.
Only sole defendant. I am the brother of the
objector.
Sole objector.
What did you adopt?
Huh?
What did you adopt?
I am not adopted, lord, my lord.
We didn't understand. You said you had adopted the
respondent petitioner prayer. Lordship, kindly page.
May
We're utterly confused.
May I clear the confusion?
Please try to.
Lordship, the probate proceeding was initially going on in some other court, my lord, where
you filed a probate case.
Lordship.
Contested.
It was contested.
They were the only contestants.
They were the only contestants.
Then?
Lordship, the probate proceeding was transferred to another court because the daughter of the applicant was a judicial officer in that court. So it was transferred. After transfer, The cross-exam, we adduced two evidences, the applicant
Witnesses.
and the one of the attesting witnesses was
PW1 and 2.
PW1, 2. They have fully cross-examined. Then they have led evidence, fully cross-examined. During argument, my lord, the learned judge said that since the issues had not been framed, I am framing the issue. So after framing the framing of issues, they have filed an application saying that I would like to further cross-examine on new issues, saying, but which issue?
Ali, if issues are framed subsequently, then the parties did not know
Lordship,
the issues.
but my lord, they have to say that this particular issue they have fully examined on with respect to my affidavit. They have not said that this issue which has arisen, which have been framed now, I have to be given opportunity to examine that the issues had been framed, Lordship. That is at page 14, all basic issues of probate proceeding. And those had been.
Do you have copies? Either of you have copies of the evidence, the examination and the cross-examination?
The puro file. Lordship, kindly we go to page 17, Lordship, my lord. Supplement, page 17, Lordship. On the prayer of the respondent petitioner, the learned trial court adopted his exonership earlier recorded. Then subsequently, my prayer has turned out.
Let us see this adoption. Yes. Both parties had adduced evidence at length.
My lord.
Then after that, they only
After that,
adopted there. Whatever cross-examination was there, this adoption application is also redundant, in fact. Whatever, if evidence has been led, even if the issues are framed subsequently, court has the power to frame issues subsequently and decide on that also. There is no issues are framed at all initially.
Lordship.
No issues are framed. So let us see the issues. The issues are usual issues.
Very usual issues of probate proceeding. Lordship, that is at page 14.
Did he execute the will? Have the properties under the will been properly and correctly valued?
Sound physical mental condition.
So see, your cross-examination was on the basis of their evidence, right?
My lord, my lord.
Whatever evidence they led, that was before you.
My lord.
You cross-examined on that.
My lord.
If they adduced fresh evidence, then we could understand that a right would accrue to you to cross-examine them further.
My lord.
But whatever your cross-examination is not on the basis of the issues. Cross-examination is on the basis of the chief. Whatever evidence was led by them, you cross-examined them at length on that.
My lord.
They only adopted that. Even without the adoption, that would be on record. And that would be the evidence on which the decision would be taken.
But my lord,
when? How could framing of issues merely later on
my lord,
give you another right to further cross-examine?
My lord.
Cross-examination right is on the basis of the examination chief, not on the basis of issues.
My lord.
Whatever may be the issues.
My lord.
I may lead evidence on something else, which you can argue should not go on record. Whatever evidence was adduced, you cross-examine on that.
My lord.
So that's complete.
But my lord, the trial court given the opportunity to respondent petitioner to adopt his exonership. If it is given, I have a statutory right to cross-examine, my lord. This is the point of law.
No, if you adduced new evidence, then you have right to cross-examine.
But once the exonership is adopted further, which is earlier recorded, then I have statutory right. Otherwise, this is not come under evidence, my lord. I have a citation, my lord.
Cite that, yes.
At moment not, but during the final trial of
which
this
moment will you get that citation? Huh? You are moving the application now. You will get the citation tomorrow.
At the final hearing,
all your citations will decide the appeal along with the application tomorrow. Bring your citations too. A short point is involved in the appeal. Footstep next para. The supplemented affidavit filed today on behalf of the petitioner be kept on record, comma, from which it transpires that initially, comma, in the probate proceeding from which the present appeal arises, comma, evidence was led by both parties, full stop. Two witnesses on behalf of the petitioner stroke respondent, that is PW1 and PW2, comma, adduced examination in chief. Full stop, both the said witnesses were cross-examined at length by the present appellant, comma, who was the defendant in the probate suit. Full stop, next para. Subsequently, comma, however, comma, it was detected that the issues had not been framed and the probate court framed the issues formally, comma, upon which, comma, on the application of the plaintiff stroke respondent, comma, the examination in chief already adduced by PW1 and PW2 was permitted to be adopted by the plaintiff stroke respondent. For sub next para, consequentially, comma, the present appellant, comma, who was the defendant in the testamentary court, comma, made an application for recall of the plaintiff's witnesses for further cross-examination on the ground that the issues had been framed later. For sub next para, learned counsel for the appellant argues that the subsequent adoption of the examination in chief by the plaintiffs entitles the defendant stroke appellant to a fresh cross-examination. First of learned counsel for the present respondent disputes such proposition and submits that the issues were formal in nature, and since both the witnesses of the plaintiff were cross-examined at length by the present appellant, comma, no further right accrued for cross-examination merely upon the issues being framed. For sub next para, since the above question is the limited conspectus of the appeal itself, comma, we dispense with filing of formal paper books. For sub, the appeal and the application shall be listed tomorrow under the same heading for being decided together.
My lord.
Thank you. Bring all your citations and bring your citations.
Lord.
And if any citation is delivered today on this point, then also bring that.
Great film.
Yes.
My lord, I'm appealing for the appellant.
Yes, Mr. Chatterjee, what is that?
My lord, previously, my lord directed me to serve.
Service affected?
My lord, service sent, but
all of them are with you?
Oh, yes. Oh,
with you, so no service.
Yes.
Service has been affected?
No, my lord, I find, my lord, we have sent much earlier, but the track report is not.
Would you like to write to the postal authority or something like, or fresh service, whatever you want?
This was booked on 9th of.
Are you enjoying any interim order?
I am enjoying an interim.
Then fresh service next month.
The interim order stood expired on 15th of. It was running in the list.
15th of
December.
The interim order granted earlier is extended stroke reimposed till February 28, 2026.
I'm sorry. I'm extremely sorry, my lord. It was still disposal of the application.
আচ্ছা তাহলে এই কথাটা কেটে দাও যেটা বললাম learned counsel for the appellant submits that due service has not yet been effected on the respondents. Accordingly, the appellant is directed to serve afresh and file an affidavit of service to that effect on the returnable date.
Furthermore, direction in paragraph 7 of the previous order, my lord has dispensed service upon respondent number 2 and 3 because they were the owners of the property. I am against the developer.
Achha,
so, my lord, kindly allow me now to serve on the owner, because if I cannot serve the developer, let the owners come in now.
No, they won't be representing the estate of the. No, whatever order is there. The matter shall next be listed in the monthly list of February 2026. Next. There may be, there may be cross purposes, but there may be, their interest may be different now. We won't take the risk.
And there was a direction to file a supplementary affidavit because I have wrongly annexed a document in the.
Only the article line at the supplementary affidavit filed to be kept on record. You also serve this?
Yes.
Item number 43.
Yes.
Lord, item number 43, Lord, along with this appeal, Lord, another appeal is required to be heard, Lord. That is, Lord, what happened, Lord, I am submitting, Lord, this appeal arising out of, Lord, the decree passed in a, Lord, the specific performance of contract.
Your suit?
Not my suit.
Their suit decreed?
Suit decreed. This is an.
What is the other appeal?
With appeal, Lord.
Other appeal?
Other appeal, yes. Before filing of this appeal, Lord, my client filed an application under order 21, rule 9700 before the learned executing court. And Lord, the setting aside the same decree, I lost there. Lord, against that order, I have filed an appeal before your lordship's court, and this is appearing, Lord, FMA number.
No, now you are challenging that you are not a party to the suit.
I was not party.
Here you have applied for leave to pay for this appeal.
My lord.
That leave has been allowed?
No, Lord.
So that has to be taken up.
It has to be.
That appeal, the other appeal has been admitted formally?
No, Lord.
It will be a second miscellaneous appeal.
So, Lord, that is the FMA number.
First miscellaneous appeal.
Yes, 13447 of 2025.
Very well. Let the present appeal be listed. Let the present appeal be listed along with effective right on a slip of paper. উনি যেটা লিখে দিচ্ছেন ওটা হবে. Under the heading Order 41 Rule 11 on January 13, 2026. Let both appear together. এটার সঙ্গে ওই FMA টা যেটা দিচ্ছে order for claim.
Lord, I already served the notice upon the other side on in view of the previous direction passed by your lordship, but he is not appearing in the present appeal.
আচ্ছা একটা লাইন অ্যাড করে দিন the file it. The receipt of notice on the learned advocate
My lord.
for the respondent filed today in court be kept on record. Bas.
Great.
Next.
The number.
The FMAT number, write it immediately. It has to go into that order. No, দেয়নি হারিয়ে ফেলেছিল দিয়ে লিখে হারিয়েছে
Cost title টাও লিখতে হবে
number will do yes
44 madam.
but are you sure that is the correct number? Yes.
44 madam, I'm appealing for the appellant.
Yes.
Lord, we have served, but the track reports are not satisfactory.
Goes out of the list.
Lord, this is something, Lord.
We won't keep this pen.
Lord, only one thing, Lord. The suit was decreed ex parte.
What is the can for?
Lord, can is my application, Lord. Where, Lord, I pray for, Lord, an order of injunction. Lord, not
He granted you injunction
initially.
No, but you cannot take indefinite time for service.
No, Lord, I say, Lord, the suit was, Lord, decreed ex parte. Let, Lord, now, Lord, we are in appeal, Lord, we attempted to serve. And Lord, let the appeal be heard out, because if they do not appear in the trial court.
No, but you have to serve at least a copy of this application.
Lord, not delivered to Howrah headquarters.
Howrah headquarters. Howrah head office. Affidavit of service filed today be kept on record. Full stop. It transpires that proper service has not been effected on the respondent. Full stop. Accordingly, the appellant shall serve copies of Can 1 of 2025 and the memorandum of the appeal on the respondents, indicating that the application shall be listed next for hearing in the monthly list of February 2026. Full stop. A further affidavit of service shall be filed on the returnable date.
Okay.
If they appear, Mr. Chatterjee, it will be easier for all of us.
Yes.
We'll try to dispose it of it. Yes. Yes, Mr. Rai.
Whatever, my lord, this direction for service of this application upon the respondent opposite party, my lord. This is a evidence service.
Good service affected?
Yes, affected, but at the relevant point, there is a dispute regarding the server updation of this. That is why the track report was not, and the track report which is there, I have get it printed, but it does not reflect. So, but from the mobile, it appears the service has been deeply affected. So, if your lordship,
why did you take a printer from that mobile or whatever?
But it appears on the site itself, but it appears that it has not been.
No, where is these are all? I mean, where is this track report?
You can deliver
This is not a track report, proper track report.
No, Joshua বলছেন এইটা তো নেই.
This is not a proper track report.
Track report নয় কিন্তু delivered on করে লেখা আছে.
Where is the track report? What is this?
Delivered. My lord, only my lord will find that this is only delivered. Apart from that, that is
Where
why.
is it stated delivered?
May I find it out for your lordship, my lord? হ্যাঁ ওইটুকুই দেখাচ্ছে আর দেখাচ্ছে না.
Are you enjoying an interim order, sir? What is the application for?
For injunction,
We did not grant interim order.
দেখে নিতে.
Injunction application, yes.
Both the parties, my lord, are claiming titles to the same person. There is no dispute about the same.
We understand, but you have to serve properly.
Yes, my lord. Service করে দিই. Or may I serve once?
Serve once again.
Yes,
file that.
I'm filing only the
affidavit of service. The affidavit of service filed today be kept on record, from which it transpires that proper service has not yet been effected. Accordingly, the appellant shall serve afresh copies of the application and the memorandum, Mr. Rai, and the memorandum of the appeal on the respondents, indicating that the matter shall be listed under the same heading in the monthly list of February 2026. Full stop. A further affidavit of service shall be filed on the returnable date.
কি বার করলি তাড়াতাড়ি করে
দাঁড়ান পরেরটা দেখা ঘুরে এসে তারপর
Well, I don't know 46, my lord, in this matter, my lord.
Yes.
My lord, I appear for the
My
respondent.
application for maintenance pending lighting.
Yes.
Your lordship, there was this solemn direction by your lordship. They filed the evidence in opposition, and I filed my reply. In my reply, you have specifically stated that they have not, in terms of the solemn judgment of the order and judgment of the Honorable Supreme Court, they have suppressed the material facts. That's why even they ought not to be heard even. Supreme Court held that even they suppress anything, that 340 proceedings may be also may be drawn up. And what is the suppression, lordship? Kindly look into, my lord. Your lordship is not well aware about this Sneha versus
My lord, may I just
Rajneesh versus
Rajneesh.
My lord, on the last
Well,
occasion,
let
your
it be
lordship
my
had
judgment.
recorded, my lord, the question as to whether I should be allowed to file my supplementary affidavit or not, my lord, that should also be decided today, my lord.
No, you.
My
So
lord-
something was missed out in your
Yes.
affidavit of asset. You want to put in a
Yes, yes.
Yes, Mr. Dattur. What is the
But,
difference in that?
specifically, I have stated that
340 is not the ultimate goal of the court. The goal of the court is to get the facts. So if they want to, whatever they have omitted, if they want to put in a supplementary affidavit, let them do it.
that is lordship.
We have to have all the facts because we ultimately we are to grant alimony to you. We have to ensure that your client gets the alimony. We appreciate what you are saying. They cannot rectify their latches by filing supplementary if this was your. But if they want to put the facts on record, let us permit that. Yes.
Well, then, my lord, if request, my lord, we may file rejoinder to that.
Yes, yes. Within a week, please file the
But
supplementary.
may I just indicate what I'm trying to
Yes.
put in through my supplementary affidavit? For that, your lordship will kindly look into my assets, my lord, the affidavit of assets that
No,
I
just
filed.
tell us.
There are 3-4 documents, my lord. Basically, my lord, I have referred to,
No, to show what? I mean,
my lord, I have indicated that, my lord, on account of my father's illness, my lord, I have to expend a lot of money. My lord, he is suffering from oral cancer. My lord, I have indicated that, but my lord, the bills and the
supporting papers you want to put.
Yes, my lord, that we have referred to here, we have not put it in by an inadvertent mistake. My lord, the additional documents are, my lord, that, my lord, I've indicated at the time.
No, you put in those. We are permitting you. You
Yes,
do it within a week and give them a copy also.
My lord, I'll do it
You are
right
ready
away. Yes,
right now.
yes, my lord, we are
So
ready with it.
we'll take it on record, give a copy to them,
Yes, yes.
and we'll give them 1 week to
My lord,
control.
copy already given? My lord, copy, I'm told that it not given, the letter down.
No, we could not because the tooth and nail we have.
Yes, my lord, on that aspect. My lord, the other point
But
of
no, not tooth
suppression.
and nail, my lord.
My lord, only nail.
But it is.
There's vicious opposition from your end. And quite correctly,
এটা কোথায়? এটা কোথায়?
And, why, my lord, I am raising my objection, my lord.
No, you have a right to.
And you also find
My lord, may I-
that they are saying that they are the Dutch citizen, but in
They
the Dutch citizen. But in the recent, my lord, SIR, they have filled up the form, and my lord, they are the other properties. They have not disclosed.
Dutch citizen or not, I mean, if they were married under Indian law, they are submitting to Indian law, they are appearing before us.
They are saying that they are the citizen of, my lord,
Deutschland,
Netherlands, my lord.
Yes, very well.
And my lord, simultaneously they are Indian. This is not dual citizenship.
Learned counsel for the appellant submits that as contemplated in Rajneesh versus Neha and another reported at 2021 2 SCC 324, unless the entire details of the income and assets of both the parties are disclosed in terms of the guidelines as given therein, the respondent husband ought not be heard to oppose the alimony application of the appellant wife. For some next para, learned counsel for the respondent husband submits that although reference has been made to certain facts in the affidavit in opposition and affidavit of assets of the husband, the specific supporting documents were not put in with the affidavit of assets, which the respondent now seeks to bring on record by way of a supplementary affidavit. For sub next para, we find that in order to adjudicate the alimony application of the appellant wife completely and meaningfully, all the relevant facts and supporting documents are required to be brought before the court. Full stop. Accordingly, we grant liberty to the respondent husband to file the supplementary affidavit as per the prayer of the respondent. Full stop. The same is filed today and kept on record. Full stop. A copy thereof is served here and now on the learned advocate for the appellant. Full stop. On the prayer of the appellant, comma, liberty is given to the appellant to file a rejoinder to the supplementary affidavit within a week from date, with a copy to the learned advocate for the respondent. Full stop. The application shall next be listed for hearing on January 14, 2026.
My lord, may I make one prayer, my lord? My lord, he has taken, my lord, in addition to the supplementary affidavit, my lord, he has taken the point and my lord, he has disclosed several documents in his affidavit in reply, saying that, my lord, I have suppressed certain properties that have been purchased by me. Will it be your lordship's pleasure to allow me to use an affidavit to that extent, my lord? Because
new properties you have brought in.
Yes, my lord.
No,
And he has said that I have
my
suppressed.
husband,
They have to explain that.
my husband purchased property. We have obtained the online information, and they have not disclosed in their affidavit. That's why those documents we have enclosed.
Yes.
No, they have to give a reply to that.
Yes.
In addition to the above, comma, leave is also granted to the respondent husband to file an exception to the. You have filed a supplementary affidavit.
No.
No, I have filed in my reply. You have disclosed the documents.
An exception to the reply of the appellant wife, comma, in order primarily to explain the allegation that the respondent husband has acquired certain assets subsequently which were suppressed by the respondent husband.
Not subsequently,
subsequently কথাটা বাদ দেবেন বাকিটা যাবে
My lord,
And my
asset
lord,
purchased by the respondent's parents as well as the respondent. My lord, these
respondent and his family.
Yes.
Purchased by respondent and his family.
my lord, only one thing, my lord, they have also filed evidence in opposition in respect to other applications. I may permitted to file reply.
First, let us decide this. Please.
So grateful. Yes.
Thank you.
47, my lord, I am appearing for the appellant.
Yes.
My lord, my affidavit of service, my lord.
My lord,
Though
I'm
service
appealing
is
on
not
behalf-
affected, my lord, but my learned senior
I am
brother is
appearing on
appeared
behalf of the respondent.
and he informed me that he have received the copies.
Very good. Yes.
My lord, it's
You are the appellant wife.
appellant wife, my lord.
Divorce granted.
Divorce granted. My lord, two applications are there. One for the alimony penalty light, my lord, and another one
Alimony will have to direct them to file opposition. Injunction.
regarding
In the two applications, short affidavits.
regarding stay, my lord.
Will grant. Identity will grant. Not stay, injunction will grant.
Injunction.
My lord. May I be candid to my lord? Prior to service of the cause papers, my lord.
Married. Remarried.
He has got so registration has not been done, but he has done the social
Under
marriage.
social marriage means under which act?
Hindu Marriage Act.
Hindu Marriage Act does not require a registration to be complete. So Hindu marriage has already taken place. This has become infructuous. Bring that on record by opposition.
Yes, ma'am.
My lord, as per my instruction, it is not done. Let them come with.
Yes, they have to show the date. Otherwise,
Since it was a social marriage, there was just a gathering and Parmilan was put in the temple, my lord. That's that which I have instructions.
then that's not marriage.
My
We'll restrain you.
Let me take instructions and we would put in a record everything.
My lord, as per my instruction, it is not done, my lord.
No, there has to be marriage by Saptapati either or by under special marriage. We'll put in that injunction order, subject to whatever has been done by.
My lord, I'm good.
On the prayer of the respondent, we will file your affidavits within a week. Both
2
applications.
weeks.
Acha, you have to file an affidavit of assets also in support of
My
that.
lord, I'm
So unless you do that, how can you file this composition opposition? You had to file your affidavit of asset, with your alimony application.
my lord, I will file it.
On the prayer of the appellant, comma, leave is granted to the appellant to file the appellant's affidavit of assets within a week from date.
Right.
Full stop. Next para, a copy thereof shall be served on the learned advocate for the respondent. Full stop. A composite affidavit in opposition to the application for alimony as well as the respondent husband's affidavit of assets shall be filed within a fortnight thereafter. The respondent husband shall file his affidavit in opposition to the application for stay also within a fortnight. Within a fortnight from date. Full stop. Next para. Since a divorce decree is in the nature of a judgment in rem, comma, we are not inclined to pass any blanket order of stay, full stop. However, comma, the respondent husband shall remain restrained from remarrying till disposal of Can 2 of 2025. In the event no such remarriage valid in the eye of law has already taken place. Full stop. Next para. Has taken place, not taken. In the event, bollam. Has not taken place. Full stop. Next para. Reply, if any, to the affidavits in opposition shall be filed within a week from the filing of the affidavit in opposition. Full stop. The applications shall be listed for hearing next on February 3, 2026.
I'm good.
So you will file your affidavit of asset,
Fine,
they will
we
file
will-
composite to that and the alimony application and their own affidavit of asset, you will file a reply to them.
Fine.
And you file your opposition and reply to the state.
I'm good.
Thank
My application. My lord have directed me to serve. My lord, I have served. They have received. My lord.
This
Result of a refusal to pass an order under Section 9 of the Hindu Marriage Act.
So, there is no scope of stay.
There's no scope of any interim order. I have also only filed an application so that the appeal may be expedited. That's all. My
To
lord.
dispose of this application.
Very well.
You have given a copy to the other side.
Yes, my lord. Affidavit of service is to.
No, the intention was that they would appear.
They would appear and it will be sent to the mediation. That is why I.
If they don't appear, whenever you choose, you can come up before the court and we'll have it to be mentioned and send it to
Very well,
mediation.
my lord.
Anyway,
Why, they appeared through legal aid before the learned trial court. Ma.
they appeared through legal aid.
In the trial court.
So they'll do the same thing here, their choice. We cannot direct them to.
No, no, I just wanted to.
Affidavit of service filed today be kept on record. Full stop. Despite service none appears for the respondent. Full stop. Next para. Can 1 of 2025 is an application for expeditious hearing of the appeal. Full stop. Since, comma, by its very nature, comma, a matrimonial proceeding is implicitly urgent, comma, Can 1 of 2025 is allowed, comma, thereby directing the appellant to put in the postal costs and due requisites for service of notice of the appeal on the respondent, comma, within a week from date, full stop. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Full stop. Next para. It is made clear that in the event the parties agree to go to mediation, comma, liberty is given to the parties to seek a formal order from this court in that regard in the meantime.
I'm extremely grateful.
Thank you. যদি না বলে থাকে affidavit বোধহয় বলেছি affidavit service filed today be kept on record.
I'm grateful.
Thank you.
I am for the petitioner. I have served upon the other side.
You're for the other side?
Yes.
Yes.
My lord, it is an ex parte order which has been passed on. My lord, it is in the memorandum appeal. It has been passed on 22/11/2023.
The one thing, the valuation statement in the memo of appeal does not tally with the valuation in the decree. What about that? Let us check that. You have stated in the
Not been informed by the department this thing.
report is there. You have to check up. They will not inform you. You have to check up your defective appeal.
My lord, valuation of this.
3,100,000 you have stated.
Yes, because the court fee has been paid by the. My lord, it is in the plaintiff 18. Page number 18 of the stay application. In the the court fee they have paid is 17,990, which is valuation is more than 1,50,000.
No, but the valuation of the suit.
But 3 lakhs is the total amount payment. They have been asking for 3 lakhs. This is
17,980.
17,990. Court fee they have paid.
No, in the decree. The decree
17 lakhs.
No, the decree, in the decree, it's written at the end of the decree, the copy of which you have annexed, প্রার্থিত প্রতিকার চুক্তি সম্বন্ধে ডিগ্রি পাইবার নিমিত্ত 17,980.
And I have to then
50 rupees for this permanent injunction, 50, 100. So 100, so then 1,880, 18 lakh, 800 something. 18 lakh and something. It does not tally, so you have to correct. What is the appeal about?
It is an appeal about the petitioner. It is an ex parte order, and which has been I filed this one after 610.
Ex parte decree in a suit for?
In a suit for Manoj, it is the petitioner's father has alleged has entered into an agreement with the respondent.
Specific performance decree.
Specific performance of the decree. My lord.
Yes, specific performance.
Performance of the decree. He has entered into an agreement with the.
The ground in the appeal? Primary ground?
The primary grounds in the appeal is that it has been delayed, and the main thing is that petitioner's father has not entered into such type of agreement. The signature in the agreement of 2010 on December 2010 is a forged signature.
Stay the operation of the decree, otherwise it
My
will
lord,
put it
in
into
my
execution.
submission, nowhere it is stated that the actual cause of delay. First, in my humble submission. Secondly, my lord,
No, delay in what? Delay in
filing the appeal. 610 days.
There's a delay in filing the appeal.
There is a delay in
huge
filing
delay. That is
600.
near
But it
about
is an ex parte order which has it has been ex parte order which has been passed in 2023, and the appellant came to know in 2025. The appellant had no idea that the advocate.
Didn't file any section 5?
Yes, section 5.
Section 5 is there.
Can 2.
Acha.
Can 2. I have filed in
Ex
section.
parte degree, so you came to know later on.
We came to know when I received the summon copy in the.
You never appeared in the suit at all.
No, I filed the written statement. After that, we were paying the money to the advocate, but the advocate didn't appear in the matter.
Then you have to give a notice to that advocate.
Yes, but I'm ready to give the advocate. Because I've changed the advocate. Another advocate is appearing. That advocate didn't give us the copy of the plaintiff anything. We have to take the certified copy of the plaintiff.
Both sides are represented before us. Full stop.
There is
Next
because the
para.
execution proceeding is
Since
going on.
certain serious allegations have been leveled against the erstwhile learned advocate appearing for the appellants previously, a copy of Can 2 of 2025, along with a notice of the returnable date, shall be served on the said erstwhile learned advocate, and an affidavit of service shall be filed to that effect on the returnable date, in order to put the learned erstwhile advocate of the appellants on notice as to the allegations leveled against him / her. Next para. The application shall next be listed on January 27, 2026, when such affidavit of service shall be filed before this court.
Let there be a stay of the execution proceeding.
No, first the section 5 has to be allowed. The learned advocate on record for the appellant shall rectify the valuation statement in the memorandum of appeal in consonance with the report of the additional stamp report, and in the meantime, please check up and just rectify you have to tally it with the plaintiff evaluation. Do that in the meantime.
I'm deeply obliged, my lord.
Have you put it into execution?
But execution is going on, my lord. My lord, next day, my lord, kindly stay.
So much delay we cannot.
Otherwise, my lord, this suit, this appeal will become in.
No, ma'am, you have leveled allegations against the advocate, you have to hear him first.
Deeply obliged.
Deeply obliged, my lord.
My lord, affidavit of service.
ওটা একটা লাইন রেকর্ড করে নেবেন প্রথমে affidavit of service filed to the প্রথমে একদম yes please 50
my lord.
for the respondent
I appear for the respondent.
Yes,
I
yes.
am slightly embarrassed to make a request. Today, my lord, I'm not there physically. This is a matter I'd like to address physically. Could it be on Thursday, subject to your lordship's convenience? Otherwise, I'll do it virtually.
No difficulty, but they would not use an opposition. That's what my understanding is.
No, I want to make some submission before any direction of opposition is
also
passed,
they have
my lord,
sought for
because your lordship has passed a stay on their application.
You are
My lord,
enjoying
I
a
have-
stay?
Yes.
So if you want to use an opposition, use it in the meantime, Mr. Mitra.
But my lord, because the stay is still disposal of the appeal. My lord, that will. May I make some submissions?
We have disposed of the stay application.
Still disposal
No,
of
your
this
lordship
appeal,
has your lordship has not.
kindly
disposed
take the
it of.
order of 12th November,
Yes.
my lord.
Please have the order.
Disposal of the application. How can
Correct.
it be disposal?
Correct. That's going until disposal of the application.
Yes.
So, my lord, kindly permit me to make some submissions on that day, and then, if necessary, I'll take directions for affidavit.
No, you cannot have it both ways.
Very well, my lord. Kindly give me very short directions, my lord.
Very well. The learned counsel for the respondent seeks some time to to file affidavit in opposition. So accordingly, the respondent number 1 series shall file their opposition to the stay application within a week from date. Reply, if any, shall be filed within 3 days thereafter. The application shall next be listed on January 20, 2026. Grateful.
Grateful.
Let's come back.
51, my lord, I am for the appellant.
Yes.
My lord,
First time?
No, my lord, it was served. My lord, the difficulty is, my lord, in the meantime, we have come to know, my lord, that the respondent number 1 has died. The sole plaintiff, my lord. And secondly, my lord, kindly, my lord, gives me a direction, my lord, to serve on the learned advocate, my lord, as well, of the other respondents, since, my lord, most of it has returned back, my lord, with the address he left.
But this is the first appeal. He no longer has may
The
not
other
have
applications, my lord, in the meantime, my lord,
it was a misappeal we could have directed because this suit is still alive. Now he has given up his brief and.
my lord, a preliminary decree has been passed.
Oh, then
Partition suit.
You are filing an affidavit of
Yes,
service.
yes,
suit.
yes.
Affidavit of service filed to be kept on record. Learned counsel for the appellant submits that since most of the postal articles sent to the respondents have returned unserved, a direction may be given to serve the learned advocate within bracket S appearing for the respondents in the trial court. Next, plaintiff has been served. One.
No, plaintiff has died. Respondent number 1 has died in the meantime.
Next para. It is further submitted that as per information, the plaintiff stroke respondent number 1 has died in the meantime, and the appellants seek to file an appropriate application for substitution of the heirs and legal representatives of the said deceased respondent number 1. Next para. Accordingly, such leave is granted. The appellants shall serve copies of the pending applications as well as the proposed application for substitution on the respondent, on the pro forma respondents through their learned advocate appearing in the code below, and file a further affidavit of service on the returnable date. Next para, the matter be listed next on February 9, 2026. Liberty is given to the learned advocate for the appellants to mention the proposed application for substitution as and when filed, to be listed along with the other applications on the returnable date.
Grateful.
In your slip, please write the returnable date and the number of the other applications so that they can.
Grateful.
Item number 52, my lord, opposition has been served upon me, but my learned advocate record could not prepare the reply, my lord, 1 week time. Next
On
week,
the prayer of the appellant, the time for filing reply is extended for a week from date. The affidavit in opposition filed to be kept on record. The matter shall next be listed on January 13, 2026.
My lord, one thing I want to bring to my lord's kind attention. I have obtained a valuation report of the suit property. I crave leave to file a supplementary affidavit to that, to put that on record.
Very well. On the prayer of learned counsel for the respondents, leave is granted to the respondents to file a supplementary affidavit for bringing on record certain further particulars and documents. Such affidavit shall be filed within a week with a copy to the learned advocate for the appellant. Exception thereto, if any, shall be filed by the appellant within a week thereafter. Let the matter be listed next for hearing on January 27, 2026.
Thank you.
27 January.
Yes,
Item number 53.
My lord, respondent number 1 to 6, my lord.
My lord, I have served the copy, my lord. As per your lordship direction, my lord, I have served all of them received, my lord. This is my affidavit of service. As per your lordship direction, I have served. The preliminary degree in the partition suit, my lord.
Usual order. What? Preliminary injunction, partition suit, you expect it, we expect us to refuse injunction? What opposition? We will say that you are not admitting any of these allegations.
My lord, expedite the matter.
Definitely we will. Since no affidavits are invited, it is deemed that none of the allegations made in the injunction application are admitted by the respondents. Next para. From the affidavit of service filed today and kept on record, it transpires that all the respondents have been served. Full stop. Next para. The appeal arises out of a preliminary degree of partition. Full stop. Accordingly, comma, we are of the opinion from the averments made in the application and on a perusal of the materials before us, comma, that the balance of convenience and inconvenience is in favor of grant of injunction as paid for by the appellant. Full stop. Accordingly, can 1 of 2025 is disposed of by restraining the respondents and or their men and agents from transferring, alienating, and or encumbering the suit property in favor of third parties in any manner till disposal of the appeal. Full stop. Furthermore, comma, the parties shall maintain status quo as regards possession, both sides, as regards their respective possessions, status quo as regards their respective physical possession. In respect of the suit property, comma, also till disposal of the appeal. Full stop. No order as to cost. Full stop. You are appealing for which of the respondents?
1 to 6, my lord.
1 to 6.
1 to
My lord.
1, 2, and 6.
1, 2, 3, 4. 5 kho, 5 go, 5 go, and 6.
Who is left out?
My lord, 5.
8, 9. 8, 9. But I have served all of them.
No, the appeal then will dispense with service of notice. If you appear for all the respondents, will dispense with service of notice.
1 to 6. 1 to 6.
1 to 6. 6 is the last respondent here.
My lord, my lord, kindly see the cause title, my lord. Kindly see.
Cause title we are looking at. 6 is the last respondent. 5 there are ko, kho, go, gho.
Yes, my lord. 5, my lord. 5 kho. I am not 5 ko. 5 kho, 5 go, and 5 go.
So 5 ko and wo are left.
Yes.
No, 5 ko is only left. So you enter appearance for 5 ko also.
But my lord, I am following the.
Very well. It will delay your matter only. The appellant shall put in postal costs and requisites for service of notice of the appeal on respondent number 5 within bracket KA, ko. No, she has also died.
Died, my lord.
5 ko deceased maybe means?
My lord, died. My lord, kindly see the coach title, my lord.
What do you mean by deceased? How can you complete a deceased?
5 ko.
Yes. My lord, kindly see.
5 ko in your application.
Deceased.
Page 5 of your application. 5 ko deceased maybe?
Yes.
This is
Your application, you look at your application.
5 Javedavi.
No, 5 ko. In can 1.
Page 5, page 5.
We can 1 waiting.
While the memo.
Don't take the advantage of his not knowing what is in his application. If she's deceased, then all you are appearing for all. Then you are appearing for all.
Yes. Yes.
Took so much time to understand that.
But my lord,
in the memo, my lord, in the memo and stay application also. In your
memo, you have stated
there is 5 ko. Your lordship kindly see.
There is 5 ko in the memo as well.
No.
No.
Page 2, your lordship kindly come.
You are looking at the appellants. We are speaking about the respondents. You are for the appellants. How can you be appear for a deceased person? We are speaking about the respondents.
Oh, yes.
5 got deceased. I mean, what do you mean? How can you implicate a deceased person? You say she is deceased. Is she actually deceased or diseased?
Certainly deceased. Certainly deceased. Otherwise,
very well.
I have implemented him.
যেখানে আগেরটা শেষ করেছি তারপর থেকে since all the respondents are represented through their learned advocate, comma, service of notice of the appeal on the respondents is dispensed with, full stop. The trial court records shall be brought by special messenger at the cost of the appellants, comma, to be deposited within a week from date, full stop. However, comma, the learned trial judge shall be entitled to retain a skeletal record for the purpose of continuing with the final degree proceedings. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Did you make an application for stay of all further proceedings or final degree? Then the final degree will be passed before this is heard out.
No, Your Lordship, kindly see, in the, my lord, the order which has been passed by Your Lordship, kindly see the, Your Lordship, my lord, assign the reason why, my lord, the final degree cannot be executed. Your Lordship, kindly see. It is a peculiar.
আচ্ছা আরেকটা লাইন অ্যাড করে দিন, the learned trial judge shall be at liberty to proceed with the final degree proceedings in the meantime.
No, Your Lordship, kindly see, paragraph.
Push up, however, comma, no final degree shall be drawn up till disposal of the present appeal.
No, Your Lordship, kindly see, my lord, paragraph 7 of the order. Your
What
Lordship,
have you
kindly
said it?
You have said that, I'm just reading, my lord. In view of the strong prima facie case in that regard, we are of the prima facie opinion that at this time, if we permit the final degree proceeding to continue, it might render a futile exercise in the event of title and possession of the parties are found out to be contrary to this record in the impugned judgment. Your Lordship recorded because it is a peculiar case wherein both the parties, my lord, I filed my lord 44-2A. That was allowed, he has withdrawn. That is why Your Lordship passed this order.
Skeleton records যে sentence সেই জায়গাটা কেটে দাও, মানে the learned trial judge will be entitled to which sentence শুধু which sentence skeleton records for the purpose of continuing with the final degree proceedings. আর কি বললাম যে in the meantime the trial court shall আর কিছু বলিনি, শেষ করলাম কোথায়? এটা কেটে দাও, এটা কেটে দাও, এটা দেওয়ার দরকার নেই, আর কিছু দেওয়ার দরকার নেই। This much.
My lord, kindly expedite in default filing the paper book, my lord. The
it comes up হয়ে গেছে।
If my learned friend agreed, appeal may be disposed of. If agreed.
Have a talk with him. If he agrees, then we'll take up the matter.
Yes.
Yes. Next.
This part has been deleted, my lord. Your Lordship.
Yes. Last part has been deleted. That remains.
Yes, that is because it is that is why Your Lordship passed this order. Number 54.
Yes.
54, my lord, I'm being short passing.
No.
On behalf of the Mr.
No, you are sufficiently senior. Move the matter. Yes, Ms. Chatterjee. What is the matter?
The last occasion.
Section 5.
Yes, my
You are appealing for the other side.
1 and 2.
No, you are not sufficiently competent. What is that?
But Mr. Tanmay Mukherjee is appearing, my lord. Only
No, so many people, then you must have a good case.
Yes,
What is the delay?
9 days delay, my lord. Only 9 days.
Your
delay, my lord.
We are allowing the section 5.
Yes.
Then we'll think about the other.
Great, my lord.
In view of sufficient explanation for the delay in preferring the appeal having been made out, can 1 of 2025 is allowed, comma, thereby condoning the delay in filing FAT 431 of 2025, push up, let the appeal be deemed to stand registered and admitted, push up, no order as to cost. Now, what is can 2? What is this appeal about?
Can, my lord.
Appeal is against what degree?
Preliminary degree, my lord.
The usual order.
But they wanted to, my lord, press the appeal on the last occasion.
Press the appeal hearing.
So that's something that is up to them. But
they will take advantage of the absence of Mr. Mukherjee.
My lord, only my lord.
No. What is the appeal about? Give us the merits of the appeal then.
Yes, my lord.
Why should you take it up along with this? What is the scope of the appeal?
they spoke about, my lord, partial partition.
You argue for them and yourself also. Both sides, yes.
They said, my lord, their
Partial
objection is that there are two properties which have not been brought into the HON'BLE. One, my lord, is the joint business. The other one, my lord, is another property where somebody else is also, my lord, a party, my lord, is an owner. So that is why courts did not say that this is a part of, my lord.
Body else cannot come in.
Cannot come in. So
and
that
business. What is your
yes.
defense on business? Joint
business also, my lord, it is
Somebody
admitted. They have admitted that if there is partition, they have no problems at all. Business also, my lord, is a completely different thing altogether. Nothing to do with in the jointness.
No, if it's a
Jointness,
joint
there was
business-
only one property, my lord, in this. My lord, there were many properties. One property was settled, my lord, by the settler by which of by this deed of settlement. It is only that property, my lord, which is being, my lord, which is there is jointness, my lord, in this co-shareage. The other properties are not, my lord, jointness. There is no jointness between
No,
these.
what about the
co-shares.
business? Business.
Even business, there are others. And it
Let's
is
request here.
being carried on from, my lord, tenanted premises. So the premises cannot be a joint property. The business, my lord, there can be something, but there also the courts have held, my lord, that it's not joint.
maybe your lordship would
Was it taken
require-
in the trial court?
Yes, yes.
What is
yes.
the finding regarding joint
My lord,
custody?
let me come back, my lord. Let me come back, my lord.
He's not in court.
Yes, my lord. He is in court, my lord.
He will be coming soon.
Judgment.
One matter is
entering the
going on,
courtroom
my
soon.
lord. Then let me come
If he
back.
does not, we'll dispose of the appeal.
Yes, my lord, let me come back, my lord. Kindly
Don't
let
come
me
back.
come back, my lord.
Don't come back. We don't want you to come back. Come back with some other matter. Yes, Mr. Chatterjee, place that relevant portion.
Yes. Kindly takes up.
Don't you see so many busy people are blocked up in this matter? How dare you ask for time?
Let me come back, my lord. Let me come back.
No, we release them as well as you.
But my lord, only 5
But let us hear the matter. Yes.
Page 8.
Where is Mr. Mukherjee stuck up? Mr. Tanmay Mukherjee? Which court? Don't know. Don't take a guess. Yes. Yes, Mr. Chatterjee.
19.
19.
my lord.
19.
Just
Lord,
Bhattacharya.
Justice, there are 4 justices.
Hiranmay Bhattacharya just.
তোর করা উচিত না মামলা
Yes, Mr. Chatterjee. Where has it been dealt with? The
Page
joint business, if it was taken.
takes up page 8.
The impugned judgment, you can refer to the internal page.
Yes, internal page 8.
8.
Please below the last but one paragraph
yes, but in some
regarding the points raised by defendant number 2 that all joint properties were not included. I have to mention here that the general rule of partition require inclusion of all joint properties in a suit for partition. But in some cases, there will be relaxation. Partial partition has been allowed where the different portion of the property lying in different jurisdiction or when the property is held jointly with stranger who cannot be joined as a party to a general suit for partition, such and such. DW2 has admitted that the property 52 MG Road is owned by his aunt along with them. The business which is being run at such and such.
Yes, one aunt, another niece or something. So therefore it has been dealt with.
Exactly.
My lord.
What is your ground?
My lord, my ground is, my lord, in my lord settlement deed, my lord, 1957, my lord, and there is a settlement deed where, my lord, my Mrs. Charubala Das, this is my mother.
Type code is
Yes, my lord, my mother, and my lord, may I hand over this, my lord, settlement, my lord.
Was this
where my-
exhibited in the trial?
my-
Was this exhibited in the trial court?
Yes, my lord.
It was.
When all daughters are not made party, my lord.
They are not kosher.
In my view, my lord, they are the necessary parties, my lord. My lord, kindly come to the.
No, non-jointed was not raised by you. Partial partition was raised. Partial partition means some of the properties, common properties have not been brought in.
Yes, my lord, and my lord, also, my lord, daughters are not made party, my lord. Where, my lord?
Daughters were excluded in that.
My lord, kindly see, my lord, second paragraph, my lord.
Yes.
Whereas, my lord,
Settler is the sole and absolute owner.
Absolute
Admittedly, Chintaharan Das was the sole and absolute owner.
Yes.
Yes, my lord.
All right.
And my lord, no, my lord, yes.
Benami name and his said wife Atho by two separate conveyances in the schedule hereto and hereinafter referred to as a trust property, whereas the settlers desirous of settling the trust property for the benefit of his said wife Charubala and his sons Chittaranjan, Chiroranjan and Chittendra Ranjan and Chittangshu Ranjan Das and of her sons and his said wife to be born hereafter upon trust hereinafter declared and concerning the same. The daughters were not even made.
After
the trust property then.
Yes.
After the death of Charubala Das, my lord, his wife, my lord, the daughters will be in the.
No, in terms of the trust they will get. They will not get it in terms of inheritance.
My lord, kindly second page, my lord. May I indicate, my lord? Kindly second page, my lord. Second page, page 2.
Yes.
3B, my lord.
Oh, Charubala was on equal footing with the sons, you were saying.
Yes,
so
ma'am.
therefore, if the sons get, Charubala's other heirs
Yes,
should also get, daughters come in.
Yes, my lord. After the death of Charubala, my lord, daughters will be in the inheritance. my
Charubala
lord.
and his sons. So you.
Lord.
Achha, next page, yes.
Next, my lord. 3, my lord. May I read, my lord?
Why are you crying? You argue properly. 3B, you are arguing very well, yes. 3B.
3B, my lord. 3A, my lord. May I read, my lord?
Yes.
Upon trust to pay.
Yes, Chatterjee, put your imposing physique on the chair.
I am not imposing. She knows well.
No, physically imposing. You just take your seat. Yes. You're intimidating the other side.
upon trust to pay the whole of the net income of the trust property to the settler's said wife, Srimati Charubala Das, for and her absolute life and benefit burning the terms of the natural life. B. My lord, after the death of the settlers, his wife, Srimati Charubala Das, the trustee shall hold the trust property charged with the payment of the same 10,000 for the marriage expenses of each of the settlers' unmarried daughter by the said Srimati Charubala Das. Upon trust for the absolute use and benefit of the sons, his said wife Srimati Charubala Das, as herein before mentioned, and absolutely in equal shares, provided always that it is hereby expressly declared that the trustees shall have the full power of grant leases and/or to convert by sale or otherwise the trust property and invest the sale proceeds in government securities.
Ms. Chatterjee, are the daughters now married?
Yes, my lord.
Now, here, you will read with you. 3A says, upon trust to pay the whole of the net incomes of the trust property to the settler's wife, Charubala, for and her absolute life and benefit during the term of her natural life. So it's a life interest given to her. And it reverts back after the death of the settler's wife, Charubala, the trustees shall hold the trust property for the marriage expenses of each of the settlers' unmarried daughters. So marriage expenses are the only right of the unmarried daughters after the demise of Charubala, as herein before mentioned. And absolutely, this is after the death of Charubala, everything.
Yes, sir.
And absolutely in equal shares, provided always that it is hereby expressly declared that the trustees shall have the full power. So these trustees, Charubala was included in the trustees, only Charubala and the sons were the trustees. So A and B speak about after the death of Charubala. So Charubala is gone, the only remaining trustees are the sons. Therefore, Charubala gets absolute word is used, but absolute life and benefit during the term of a natural life. So life interest is given to Charubala only. After her demise, charge on the property for marriage of the unmarried daughters. And otherwise, absolutely in equal shares to the other trustees who can do everything, sale, whatever. So therefore, Mr. Chatterjee is, for a change, he is right. For a change, he is right. Because you answer us, we are open to answer. If you have convinced you, keep shut, we'll dispose of the appeal right now. And we'll record Mr. Mukherjee's name. If you are convinced by us, then say that. Otherwise, you convince us.
Mr. Mukherjee has something
What can
to
be an
say, my
alternative argument on this?
Mr. Mukherjee, something to say, my lord. That's
What? We must have had a conference. What would he say? Must have had a conference. This is your entire argument. Then let us hear Mr. Chatterjee something else. Yes. Mr. Chatterjee also covered their points. If there is any point in there.
Yeah, I'm saying so, my lord. They have said that they don't have any problems if the property is, my lord, partitioned. They have said that there is no other owner in this property. In their cross-examination,
Have you
they
got a
have
hard
admitted.
copy of that cross-examination? We have to keep something on record. There is a
My lord,
difficulty.
your lordship keeps this.
No, we are. You are saying we go by your statement, but we have to keep some hard copy on record.
Give it within, my lord. If Mr. Mukherjee,
Read that portion. You share it with Ms. Chatterjee and just read it out.
I'll read it for you.
Yes.
I have filed my examination chief on affidavit.
This is cross-examination PW?
PW by PW.
DW. They were defendants.
Yes.
Which defendant? DW.
Two, my lord. No, it is a PW. This should be DW2.
It's written PW. So check up whether it's you. Maybe you also.
Cross-examination of PW2 by different numbers 1, 3, 4, and 5 is resumed.
Then you had said that.
Yes.
So therefore,
And
it's
also them.
let us see the DW cross-examination.
DW টা কোথায় গেল? এটা তো PW টা।
You have confused.
You will be alert. It's there, my lord.
You have seen that?
Yes, yes. ভয় পাচ্ছিস কেন? তুইও তো
সে হিরণময় ওই জায়গা থেকে নিচ্ছে নাকি? হিরণময়ের কাছে পড়ছে মামলাটা। In the meantime, send a special messenger to Mr. Mukherjee
Hmm.
at your cost to be deposited within a second. Yes.
I have no objection to the prayer.
DW, check up P or D.
DW2, defend number 2.
Defendant number
Defend
DW
number
how?
DW2 dated 8/1/2018, only contesting defendant.
DW2 8/1/2018.
18. I have no objection to the prayer of the plaintiffs praying for partition. The share which has been claimed by the plaintiffs are correct. Then,
yes,
ভুল হচ্ছে না তো আমার cross examination on behalf of the plaintiffs ঠিকই তো রয়েছে।
yes,
there are no other properties except the properties mentioned in schedule of the plaint which are which are in the joint name of ours. Then volunteers that the properties at 12B Russell Street belongs to all the parties of the suit and the daughter of my elder aunt. Admission that there's somebody else.
Volunteers, probably we cannot take it as an admission.
Volunteers, he tells it on his own that there is somebody else.
Cannot go on record.
Very well, Miller, but
Even then, they have not proved otherwise.
Nothing. They have said that there is a party. And the property situated at Mahatma Gandhi Road and the property at 30 Rafi Ahmad Kidwai Road belongs to us. That is all the parties in the suit and all the 4 aunts. All the 4 aunts are not parties in the instance. Because the daughters are not made pillar in the... So this is a part of their cross-examination.
Yes, what else, Mr.
In our WS written statement, my lord, we have also stated, my lord, all the properties has not met.
That has been dealt with by the trial court. You show us otherwise. You show us otherwise something to say that anything was exhibited in the trial court to show that those properties belong to exclusively to the parties.
No.
The exhibit list is before us. Your KMC trade license, printed rent receipt, 5 rent receipts only. So then we'll decide the appeal right now. In view of the short conspectus of the appeal, the same is taken up for hearing by dispensation of formal preparation of paper books, along with the injunction stay application. For the next para, the present appeal has been preferred against this is a preliminary degree.
Yes.
A preliminary degree of partition. Full stop. Next para, the primary contention of the defendant stroke appellants before this court is twofold. Full stop. First, that some of the daughters of the original absolute owner Chintaharan Das have not been impleaded as parties to the suit, thereby rendering the partition suit bad for non-joinder of necessary parties. Full stop. Secondly, some of the joint properties belonging to the parties have not been brought within the hotspot of the partition suit, thereby vitiating the suit in its present form for partial partition. Full stop. Next para. Learned counsel for the appellant hands over copies of a deed of settlement, which was exhibited in the trial court, to reiterate that in terms of the said deed, the said original owner Chintaharan Das had created a trust and included Srimati Charubala Das, his wife, along with his sons, as trustees. It is, thus, contended that upon the demise of Charubala, the daughters of Chintaharan Das and Charubala would be entitled, in the capacity of heirs of Charubala Das, to be co-owners of the property, although not made trustees directly in the deed of settlement. Full stop. Next para, that apart, learned counsel for the appellant relies on the written statement of the defendant appellant in the trial court, where it was pleaded that the suit is bad for partial partition, since certain other properties, which are also joint properties between the parties, have not been brought on record. Full stop. Next para, learned senior counsel appearing for the plaintiff stroke respondents argues that even from the deed of settlement dated March 4, 1957, relied on by the defendant number 2 stroke appellant, comma, it is evident that merely life interest was given to Srimati Charubala Das. Thereafter, comma, the property was to devolve absolutely to the remaining trustees, comma, that is the sons of Chintaharan Das. Next para. Hence, comma, it is argued that the daughters of Chintaharan are not co-owners and cannot be necessary parties to the partition suit. Insofar as the partial partition argument is concerned, comma, learned senior counsel places reliance on the relevant portions of the impugned judgment, where the learned trial judge dealt with the said contention and placed reliance on the evidence, reliance on the admission of the defendant stroke appellant as DW2, comma, to the effect that a business was being run at 12 capital B, comma, Russell Street, comma, which is owned not exclusively by the present parties, but also one niece, comma, Seema Bose, apart from the parties to the partition suit. Next para. On the premise of such admission, comma, the learned trial judge, comma, it is pointed out, comma, proceeded to come to the conclusion that the suit is perfectly maintainable in its present form and accordingly granted the preliminary decree therein. Next para. Upon hearing learned counsel for the parties, comma, we find substance in the contentions of the plaintiff stroke respondents, inasmuch as the deed of settlement dated March 4, 1957, comma, although nominating Srimati Charubala Das, comma, the wife of the settler Chintaharan Das, as one of the trustees, along with the other sons of Chintaharan, comma, categorically mentions in clause 3 within bracket small a thereof that the said Charubala had only life interest during her natural life in the property. Clause subclause small b of clause 3 of the said deed of settlement dated March 4, 1957 specifies in no uncertain terms that after the demise of the settler's wife Charubala, comma, the property would devolve absolutely in equal shares on the other trustees, comma, that is the sons of Chintaharan, comma, subject only to the rider that there would be a rider that the expenses of the marriage for the then unmarried daughters of the settler would be borne out of the trust estate. Next para. Upon query of this court, comma, learned counsel for the appellant submits that the daughters of the settler have since been married. As such, comma, there is not even any scope of any charge of the property for such matrimonial expenses. Even otherwise, comma, in our opinion, comma, a charge cannot be elevated to the plane, PLANE, of title in the property. Be that as it may, comma, since in view of the deed of settlement itself, comma, it is evident that the property devolved after the demise of Charubala on the sons of Chintaharan, comma, the original owner, comma, the ground of non-joinder cannot be as accepted. Next para. Insofar as partial partition is concerned, comma, learned senior counsel for the plaintiff stroke respondents places reliance on the admission of DW2 within bracket the defendant number 2 stroke appellant bracket closed dated January 8, 2018, where it was admitted by DW2 that she had no objection to partition being effected, and also admitted that the parties have share in the property. Next para. From the exhibit list recorded in the impugned judgment, comma, we find that the defendants only exhibited certain KMC trade license and receipt of certificate of enlistment, comma, as well as printed rent receipts, and no document to indicate that a part of the property or some other property was jointly owned by the parties to the present litigation exclusively. Full stop. In fact, comma, the learned trial judge has come to a justified conclusion by consideration of the admission of DW2 that the property at 52 MG Road is owned by the aunt of the defendant along with the present parties, as well as that the business run at 12 capital B Russell Street is owned by one niece, Sima Bose, apart from the present parties, comma, thereby taking both such properties, comma, immovable and movable, comma, outside the ambit of exclusively owned joint properties by the present parties. For sub next para, it is well settled that if a property is owned jointly by the present parties along with a stranger to the suit, comma, which stranger is not a co-owner in respect of the other properties brought within the hodgepodge of a partition suit, comma, the said property where the stranger is a co-owner shall not come within the purview of the partition suit. Full stop. As such, comma, we are of the opinion that the learned trial judge exercised discretion judicially and correctly on the basis of the materials on record and the admission of the defendant number 2 stroke appellant to pass the preliminary decree and negating the contentions of non-joinder and partial partition raised by the defendant number 2 stroke appellant. Full stop. Accordingly, comma, there is no scope of interference in the appeal. Hence, FAT 431 of 2025 is dismissed on contest, thereby affirming the impugned judgment and decree dated July 28, 2025, passed by the learned judge, comma, 11th bench, City Civil Court at Calcutta, in title suit number 1568 of 2023. Full stop. Consequentially, can 2 of 2025 is also disposed of. Full stop. There will be no orders to cost, comma, formal decree be drawn up accordingly. Full stop. The records have come. No.
No.
That's this much.
Can it be disposed of?
Your lordship will
Can I say can one bolam?
can one টা আগে করতে can one টা section 5
That has already been allowed. Yes. So can 2 has to be disposed.
Instead of dismissed, can it be disposed of?
We are affirming the judgment. Inform Mr. Mukherjee. No.
But here,
What were you to say?
two things. Have your lordship gone through the settlement deed?
Yes, and
the settlement deed, there is a explicit provision that I am one of these. My mother was one of the settlees.
Trustees.
Yes, trustees.
3B, 3AB.
I have read.
3AB. Quick, you are on borrowed time, so you get 2 minutes.
May I just
2 minutes.
Yes, 2 minutes. I will conclude.
3AB.
Kindly consider. Yes.
Get over 3AB.
3A is the provision wherefrom my mother can get the profit. Kindly see. And
during her
lifetime. Yes.
natural life.
Yes. 3B. Kindly consider the language.
Marriage, matrimonial expenses.
Not only that, after the language is upon trust for the absolute is after the death of the settlers. We should stop here. His wife Charubala Das, the trustee shall hold the trust property, charged with the payment of the same for 10,000 for the daughters. Bracket close. I am not. Upon trust for the absolute use and benefit of his sons, his wife Sri Charubala Das. So the settler is conscious. My wife will get the entire benefit till the date of her lifetime, natural lifetime. But after this 10,000 is a charge for the marriage daughters, they will. But after that, the trust will comes to what? Upon trust to the absolute use and benefit of his sons, his said wife Sri Charubala Das, as herein before mentioned, and absolutely in equal share, provided always that it is hereby expressly declared that the trustees, again the word is trustees, shall have the full power to grant lease and or convert by sale
Because you have
or
considered-
otherwise.
You have considered and interpreted.
Milord, here, Milord, kindly consider
You have
section
considered
14 of the
and
Hindu
you have
Sanction Act.
admitted that the other properties, your niece